Where is that assignment? We don't have any assignment. দেখে নাও assignment পেলে দেবে বেঞ্চ করতে হবে একটা তাহলে
Lord, may I be permitted to mention one mandamus appeal assigned to this honorable bench for inclusion, my lord?
Inclusion, don't waste time, just hand over the slip.
My lord.
Bail in connection with it.
I'm sorry.
Bail in connection with application.
My lord, bail is connection with appeal. Bail in connection with appeal.
Lordship, may I humbly mention one matter, my lord? This is the matter of custodial torture. It has a special division bench has been formed by Honorable the then Chief Justice, Justice Shivagnanam. And my lord, the matter once appeared before your lordship a review application regarding a custodial torture in Diamond Harbour Police Station. The matter has been assigned before your lordship and lordship, my lord Gaurang Kant, my lord, a special bench. Lordship, the urgency is, my lord, based on a perfunctory allegation.
You give the slip, bench করতে হবে, bench করো শোনো.
Lordship, only the urgency is in a supersonic speed.
We cannot
date of charge has been.
Sir, we cannot do it yesterday. We cannot do it today.
Lordship.
So just let the papers come. We'll do it as soon as possible.
Lordship.
My lord, I want to mention one thing, my lord. If your lordship allow me, then I speak, my lord. My lord, item number 66. My lord, it may kindly be upgraded and take the matter tomorrow, my lord, at any time. As because, my lord, custody period has already been over. Maximum period has already been over, my lord.
To be mentioned tomorrow. Give notice.
Out of 10 years, my lord, 8 years have been passed, my lord. To be mentioned, my lord. Yes, my lord. I will give notice.
Nothing.
My lord, I will give notice, my lord. Sorry, my lord. Sorry. I will give notice.
Koro. Next.
Lord, may I have my lord's leave to mention, my lord? My lord, an order was passed on 3rd of September, my lord.
Clarify করে দিতে হবে।
My lord, this is a clarification application we have taken out by the order was passed by my lord Justice Showmanship and my lord Justice presiding over Mr. Apurva Sinha. My lord, I have taken out a clarification application, my lord.
That will come here. That will come here because my lord is here.
My lord.
Is there such a কোথাও আছে বলা?
This is the first appeal.
My lord, there is a notification in the appellate side rules, my lord. The clarification application will be before. Otherwise, I could have mentioned before the bench who is taking the regular determination.
All right, list it.
Lordship, can it be listed on Monday?
We don't know. Let the papers are here. Let the papers come.
Lordship.
Grateful, Your Lordship.
সবাই দুপক্ষই আছে মনে হচ্ছে।
Circuit bench of Port Blair matter.
My lord, I am appearing for the respondent.
Yes, Mr. Shanto.
May
My lord, I am appearing for the respondent in this matter.
I am for the appellate.
the circuit bench matter.
Where's your other side?
My lord, I am appearing for the respondent, my lord.
Mr. Rakesh Kumar Prabhu.
Yes, my lord.
I had given him personally notice also and I have served a copy. Lord, it's very short point, Lord. The appellant before my lord was operating the restaurant Lighthouse at the Port Blair near that Netaji Subhash statue for the last 31 years. He got it by virtue of an open tender 1994, and thereafter there have been extensions continuously, and ultimately, my lord, the Port Blair Municipal Corporation Council had made a unanimous resolution extending his period of lease on terms as concerned. My lord, notwithstanding the unanimous resolution, the secretary started a tender process. We challenged the tender process. The learned single judge passed an order. Because highest amount should be gathered, therefore, let the tender process proceed and we'll consider the matter again. That was the first day. Without prejudice, I participated in the tender process. I emerged as H1. But, my lord, my submission was the tender could not have been at all taken up because of the unanimous resolution. The secretary had no power under the rules to do anything other than accept the unanimous resolution unless the administrator, that is the lieutenant governor, gives a decision otherwise. That was not done, in my humble submission. But after that, we have given the money. Now, I am before your lordship on the small point whether a unanimous resolution could be given the go-by by the secretary and a tender process initiated. This is the short point.
Let us read the impugned order.
Lordship.
Give us 2 minutes. Give us 2 minutes.
Lordship. The impugned order, Lord, there are two orders.
এটা এমন ভাবে রেখেছেন আমি পাশে অ্যাডভোকেট বা কাউকে দেখতে পাবো
My lord, the first order at the motion stage is at page 163.
Impugned order is 24th September.
Yes, my lord. 165.
The municipal council is a statutory body. It's the duty of the council to ensure that the maximum revenue is fetched. Could it have, without inviting tender, decided to extend the lease?
But because it is a resolution, because ultimately, my lord,
Whatever be, maybe unanimous resolution of the members of the council, doesn't matter. Ultimately, we are concerned with public money.
my lord, here, if I'll show your lordship one paragraph, my lord. Thereafter, my lord, your lordship thinks. I know that that is the very simple proposition, but this proposition will not hold water because of the facts, my lord, here that I am the
Anyway, Mr. Shamanto, we have to hear out the appeal. There is no question of stay or anything. You have now put in the money.
yes, I have
Yes,
put the money. It will be abide by the
Abide
result
by
of
the
the
result of the appeal. All papers are, have you filed all papers?
everything is
Everything?
there.
So we'll fix the appeal for hearing. This appeal is directed against a judgment and order dated September 24, 2025, passed by a learned judge of this court in WPA number 449 of 2025, being a writ petition filed by the appellant herein. Paragraph. In short, the grievance of the appellant oblique writ petitioner is that since 1974,
94 million.
94, since 1994, he has been running, it's called Lighthouse Restaurant.
Lighthouse restaurant,
A restaurant by the name of Lighthouse,
which was obtained by an open tender in that year.
under lease from the Port Blair Municipal Council, bracketed PBMC, which was executed in favor of the appellant by PBMC pursuant to a tender process in which the appellant emerged as H1. From time to time, such lease was extended.
Page 120, if your lordship sees, it will be easier for your lordship. Page 120, where the fact is. Tender at the top. Tender of Lighthouse restaurant. All facts are there.
Now, this tender process initiated by the secretary was this year,
This year
Yes.
and the unanimous resolution.
of this year. Resolution is agenda number 14
This
of,
year.
of
The date of the resolution.
yes.
Next. The appellant says that
7/8/2025.
by an unanimous resolution dated August 7, 2025, the members of the PBMC decided to further extend or renew the lease in favor of the appellant. In spite thereof, the secretary of PBMC decided to initiate, and in fact initiated a fresh tender process. This was challenged by the appellant before the learned single judge. Paragraph. By way of, no interim restraint order was passed by the learned single judge. The tender process was allowed to proceed, granting liberty to the appellant oblique writ petitioner to participate in the tender process without prejudice to his rights and contentions. The writ petitioner duly participated and emerged as H1 again. He has also put in the requisite money with PBMC and is running the restaurant.
That is for 1 year. 1 year.
Paragraph. Finally, when the writ petition came up before the learned single judge, the learned judge noted that the tender process has been completed comma, the writ petitioner has participated therein, stop. Therefore, without interfering, comma, the learned judge also noted that it is the duty of PBMC to see that maximum revenue is fetched in connection with leasing out the Lighthouse restaurant, Lighthouse within inverted comma. Stop. Therefore, comma, without interfering, comma, the learned single judge disposed of the writ petition. Stop. Hence, this appeal. Paragraph. Mr. Shamanto, comma, learned senior counsel representing the appellant, in his usual fairness, says that there is very little scope of passing any interim order. Stop. The payment made by the appellant will naturally abide by the result of this appeal. Stop. Paragraph. We understand that all papers that were available before the learned single judge have been annexed to the stay application. Stop. We propose to hear out the appeal, treating the stay application as an informal paper book. Stop. All formalities are dispensed with. Stop. Since the respondents are represented through learned counsel, appearing on the virtual mode, comma, notice of appeal is deemed to be waived. Paragraph. The stay application is disposed of. Stop. Paragraph lists the appeal for hearing under the appropriate heading when 1 week hence.
1 week hence.
Next Thursday, next Thursday. Stop. At the time of hearing of the appeal, the stay application should be made available before us. Bujecho?
My lord.
So you are initially given 15 years.
15 years.
15 years, my lord, thereafter.
Started from 2010 and
94,
94.
then 2010 again. 31 years we have continued. 31 years. And we are giving the highest revenue. All that is recorded in the
That's all
resolution.
right, Mr. Shamanto. What little we have read now, it appears to be the stand of the PBMC administration that the unanimous resolution of the council did not have the approval of the competent authority.
Right.
That is the stand, right, wrong? So we will see it when we hear the appeal.
That's Well, I was relying upon Tata Cellular to show that the court will not look into anything if it is a policy decision. Here it's a policy decision where unanimously given. And all the time, Lord, the courts always say, unless there is something very wrong in an action, you should not do something other than that.
No, all very well, but where public exchequer is concerned,
Even then, Lord, the question is,
Lord,
so if it
Has
is
to
a
be-
unanimous
there has to
resolution,
be transparency, Mr. Shamanto. The people at large should know that the best possible revenue, everybody has had a chance to participate.
well, that's the normal principle. but
Otherwise,
here-
there's possibility of corruption. We are not saying there is corruption. There's possibility of corruption.
Definitely, Milord, I bow down to that. But Milord, only one thing.
Yes.
There are 42 persons in the resolution who had signed.
24, my lord, I think, sir. Subject to correction. 24, I'm sorry, subject to correction. My
So-
lord, more that regulation itself bars, my lord. If there is any resolution which is
All
wrong,
right, Mr. Kumar, you
yes, I'm sorry, my lord.
for the next occasion.
Yes, my lord, yes, my lord. I'm sorry, my lord.
It's always a pleasure to hear you.
Lord, I'm the principal bench.
Hey, please, my lord, I can leave, my lord.
Yes, you can leave. You want to come down to Calcutta? The weather is very nice.
No, my lord. Because
no,
yes, circuit is coming from 17th.
No, it's very difficult to hear you. You know, the connectivity is not always good.
Yes, my lord.
But because it's winter, Milord, it's better. Now it's better.
So, and the weather is very nice. If we can't hear half of your
I,
session, then
I
how-
will talk to the administration, my lord, if they are permitted. Oblige, my lord.
I can arrange for him to stay.
Oblige, my lord. Oblige. I leave. I may permit. Oblige.
yes.
The only thing you mentioned.
Oh. Okay. available on the exhibition.
Yes, my lord. Circuit is from 18th, 17th, my lord. From Monday it starts.
Then why should we hear it?
My
In
lord,
fact, we can't hear
that's
it.
why I requested.
Sorry.
Yes, I'm sorry. my lord.
You should open up your mind.
My
This is
lord, I thought my lord is fixing it's taking my lord over my lord's bench, so that's why I should not made that submission.
আমি পালিয়ে গেছে না অন্যটা ডাকুন
শোনো দুটোর সময় তো হবে না, কালকে তাহলে এক কাজ করে টু বি মেনশন, টুমরো ইট উইল বি লিস্টেড টু বি মেনশন।
Yes, my lord. Yes, my lord. Oblige.
আজকে শুনে ডিসপ্লে হয়ে গেছে
Principal bench, item number 1.
এখন কি আছে
নন প্রসিকিউশন,
I am for the appellant.
এনি ইনস্ট্রাকশন?
Instructions.
Learned advocate for the appellant submits that he has instruction not to proceed with this appeal. Stop. Let the written instruction be kept with the records. Paragraph CRA, whatever, such and such, is dismissed along with Tran 2 of 2023.
how many instructions are there how many instructions are
On
there?
instructions, sir, 2 copies.
But there are so many people I don't know
Both are same.
How many people were there?
item number 2 to
Item number 1,
oh sorry
principal
Sorry.
bench.
একদম আলাদা
2 to 5.
My lord, I am appearing in connection with my lord. PRA number 331 324.
Why has to be
And
mentioned, Mr. Moitro? Why to be mentioned?
My lord, difficulty is for this reason possibly, my lord. So far 331 is concerned, there is one application for appropriate order.
Yes.
That, my lord, application possibly is not found in the record. And my lord, that application for appropriate order in respect of a juvenile, my lord, and this appeal is not, my lord, so to say, analogous to other appeal.
নাম্বার 15 টা কোনটা আমি বুঝতে পারছি
15, do you know?
Not the formal FIR is exhibit 15.
exhibit
Fif-
FIR
15, 1 5.
ফর্মাল FIR এই যে 15 লিখেছে তো এবার ডকুমেন্টে মেসেজ এটা লিখে এটা নিজেরা এটা ইগনোর করে এটা করে দিলেই হয় এটা করে দিচ্ছি দাদা একবার দেখে একবার দেখে ফোরটিন 16 এবার সেইটা কোথায় গেল ফর্মাল FIR-টাই যদি না থাকে তো মুশকিল হয়ে যাবে
FIR was executed.
Exhibit 15.
ফর্মাল FIR মানে that is
Only the formal part.
formal parts যেখানে লেখা থাকে FIR এই ফর্মাল
The form, my lord, the form.
Please look into the file. We can't see that formal form. That is the defect that they have indicated.
formal FIR is not
Both of you look into it. We just say not today, come back tomorrow.
Very good.
Then we can pass appropriate direction on the department.
who is the state go through this in exhibit list it has been mentioned in formal FIR that is
Eta
missing
dekho to,
item.
eta dekho. This is the defect mentioned by the department. Look at it.
Oh, no, I got it in the this exhibit list এখানে বড় এইখানে exhibit এটা কোনো মার্ক
What does it
করা
mean?
হয়
The FIR copy, the exhibit.
15 লেখা নেই এবার হচ্ছে কি who deposed deposition থেকে বার করা যাবে
Because probably what subject to correction my lord, it indicates is that the document is there, but the exhibit number has not been mentioned.
yes that is
Correct.
ইগনোর করে করে দিতে পারি
So
ওনাকে
this can be ignored. This can be ignored. Paper book can be filed. দাও আমার ফাইলটা দাও
go through this is the form
আমার ফাইলটা দাও
Inadvertently, this was not marked probably.
but in the exhibit list it has been mentioned
Yes, my lord. Even in the judgment, I have seen.
certainly the relevant witness has also mentioned this
It doesn't turn anything, my lord. Doesn't turn anything.
এসো A departmental note dated July 25, 2025 says that the TCR says that there are anomalies in the TCR. Stop. The FIR copy which was exhibited as exhibit number 15
and mentioned in the exhibit list
and mentioned in the exhibit list, comma, does not bear the number 15. ঠিক আছে? Paragraph, the department is directed to ignore such an minor anomaly and prepare paper book, requisite number of paper book within 6 weeks from date. Paragraph, let the matter appear in the monthly list of January.
আমি একটা দেখছি
Hmm.
সমস্ত জায়গায় সব জায়গায় সই করেছে একটা জায়গায়
14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24.
This is a very old appeal of 1967. Dekhe nahi year gulo. Stop. The appellant has taken no step to proceed with the appeal. Stop. Obviously, the appellant is not interested. Now, the appellant has taken no step to have the appeal heard. Stop. Obviously, the appellant is not interested to proceed with the appeal. Paragraph MA such and such is dismissed. Stop. Interim order, if any. In the first call, nobody appeared for the appellant. Stop. In the second call, also nobody appears. Stop. Paragraph MA such and such is dismissed. So interim order. আচ্ছা একটা ষোলো তো এদিকে আপলোড হয়নি হ্যাঁ আপলোড হয়েছে
Number.
Item 25,
25, my lord. Beg to represent the appellant, my lord. Fine. Led by learned Advocate General. Lord, may I place the case, Lordship?
No, what place the case? Where's your other side, Mr. Karim? Please look to your right once and see.
But
Where's your affidavit of service?
everything is upon notice, Lordship.
Where's your affidavit of service?
Service. Notice. My lord, notice, my lord.
Your junior doesn't know that an affidavit of service has to be filed.
Sir, I am petitioner. Lawyer sahab আসতেছেন time 25 নম্বর
25 petition, মানে respondent.
25.
respondent
Gourango Odhikari.
He is guilty of contempt, the BLLRO.
Oh,
And the respondent, my lord, this petitioner is facing contempt. He has been held guilty of contempt by the honorable single judge.
pass over. His advocate is not here. Daku. Contempt is payment of 15,000 rupees. How much?
15,000 rupees.
And
And that has to be reflected in the service
in
record.
default?
In default, nothing.
Nothing.
But
But he's not going to jail.
my lord, the question is, my lord,
Question we'll hear when we take up the
happy
matter.
with the complaint. Now, tomorrow is the returnable date before the honorable single judge.
What can be done? You don't even have an affidavit of service.
My lord, he is already there. He is asking for time on behalf of his lawyer.
Okay. If he was not here, then
No, he has been put on notice, sufficient notice, my lord.
where is the affidavit of service?
My lord, that is, my lord, a lapse on the part of my lord.
Yes, we don't like
But-
these lapses, Mr. Gali.
My lord, WhatsApp.
Pass over, let us see. Daku.
26,
Madam, for the appellant, my lord.
Yes.
There had been direction for service of CRAN, my lord. Delay of 3 days. Affidavit of service.
Yes. Yeah, for the state.
Fine.
3 days condoned. No. Wait, there's a delay of 3 days for causes shown being sufficient. Delay is condoned. Then usual order. This is an appeal against an order of conviction.
Deeply obliged, Lordship.
Cran 1, Cran 1 disposed of.
Hmm. 27.
No, I'm paying for the licensing company, my lord.
For my application, at my instance.
Who is for Shumangal Ishpat?
My application, man.
Your application.
It's his application, my lord.
Your
There are
respondent is the
there are two sets of appeal. One by DVC, one by the this petitioners. Shumangal is I am appearing for the Shumangal Ispat Private Limited.
Shumangal is a respondent.
Respondent appeal.
Where is your appeal?
My lord, we have filed an application in connection with their appeal.
You said there are 2 appeals.
Sets of appeal. My lord, there are some consumers who had filed. I was not part of that consumers. DVC had also filed. 2 separate orders were passed, from which 2 separate sets of appeal, but they were taken together because they were interconnected. May I just indicate the facts? My 2 minutes. A lot of matters. My lord, initially all the consumers, many consumers had challenged a tariff order.
You are for IPCL.
I am from DVC.
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 But DVC is the answering respondent here.
Answering respondent.
DVC is the one against whom I am seeking the prayer, man.
Yes.
Because any order they are seeking here would be, my lord, modifying a Supreme Court order. That is my preliminary objection, my lord. There is already an order, SLP disposed of whatever order they are
Let me
seeking now.
place my, if my lord finds that this application is not maintainable, my lord would pass that. Just, my lord, 2 minutes. My lord, 5th May 2022, a tariff order was passed for the period 2017-18. Many consumers
Passed by
Regulatory Commission, West Bengal Electricity Regulatory Commission. The retail tariff was determined vis-a-vis the DVC, the consumers of 17-18 after 5 years. This became the subject matter of challenge in a number of writ petitions on the principal ground that there cannot be a single year tariff. Initially, all the consumers were protected that the area charges, which was the result of that tariff order, was stayed. Ultimately, in the month of February 2023, the writ petition got dismissed. In the meantime, some of the consumers had approached Appellate Tribunal for Electricity. There was a interim order of stay of the order saying that this will open up many other litigations. We are staying this for all the consumers. Now, my lord, we challenged some of the consumers after dismissal of the writ petition, challenged it before the division bench. And dismissal, my lord, resulted into a disconnection notices that was separately challenged before the Honorable Single Judge. Honorable Single Judge said, because of the order of the APTEL of 1st July, where this interim order has been made in rem or to all consumers, so these consumers, although they have challenged it in the writ petition, they are protected by the such order. DVC prefers an appeal. This is what that appeal. DVC prefers an appeal. Both this set of appeals were taken up together on 9th April 2025. Well, therein, the division bench was pleased to stay the area charges on the ground that the consumers were enjoying an interim order. That was in tender acknowledgement, that was in the year 24. In the meantime, APTEL modifies the order. Says 50% of the area charge has to be paid and 50% has to be secured by way of a bank guarantee. That was passed on 17 January 2025. Well, thereafter, DVC had filed an application saying that all orders should be at parity. All the consumers should be treated in the same on parity, and therefore, Honorable Division Bench was pleased to modify the order. To that extent, with giving some extra time for paying 50% and securing the 50%. Well, again, we approached the division bench saying that we are having hardship, financial hardship. Honorable division bench was pleased to extend that. Thereafter, some of the two consumers had approached the Honorable Supreme Court, whereby Honorable Supreme Court, after being satisfied that 50% has already been paid, the part of for the 50%, the part for the security deposit, which had to be secured by way of a bank guarantee, was extended for 6 months. In the meantime, and what I am saying, it's a changed circumstance. In the meantime, there has been a further tariff order, further order by APTEL, wherefrom it would appear the consumers are entitled to some refund. But refund. And this refund, the calculation, we have done a calculation, according to us, this refund would not only cover the entire dues of 17-18, but it would also cover the 50%.
So you say you don't want to give the bank guarantee, furnish the bank guarantee.
I am saying, because there is a direction to crystallize this, whatever our refund would be. If by WBRC within 15th December. So I was praying for the time being, they should not take any coercive action. Till this, if it is found, today, but I have mentioned in paragraph 28.
Nothing. We'll not pass any order which even remotely will have the effect of modifying the.
But I told them, I have also feeling that this should have been before.
Go there. Supreme Court may give you whatever relief you want. Sorry, either you withdraw this, we'll say that we are not inclined to in view of, because in our opinion, this may amount to modification of.
Passes an order, but my instruction is, I was not in favor, I'll be honest,
issue. This application to dao bhai.
Application.
173 is the Supreme Court order, my lord.
This application, এটা হচ্ছে তোমার CRAN 5, has been taken out by the respondent number 1 in the appeal, bracketed Shumongol Ishpat Private Limited, bracket closed. Praying for the following orders, page 16 থেকে
একটাই তো application.
A আর B. A আর B. Paragraph. This litigation has a checkered history, so we need not delve into that for the time being. Paragraph. Suffice it to say that the consumers of electricity, including Shumongol, came under an obligation to pay 50% of the area charges to DVC.
Yes, ma'am. DVC.
To Damodar Valley Corporation, the appellant herein, bracket in short DVC, bracket close, and to secure by way of bank guarantee
the remaining 50%.
The remaining 50% of the area charges. Stop. This issue was carried to the Honorable Supreme Court by some of the consumers. Order
Same, including this petition.
including Shumongol. Page
173, my lord. 26th May 25 is the order.
Stop. The learned Supreme Court, the Honorable Supreme Court, disposed of the special leave petition filed by Shumongol by an order dated
26th May.
May 26, 2025, which reads as follows. Page 173 থেকে, paragraph 1. ওই paragraph 1 is a sub-para আছে, হ্যাঁ? Paragraph 1 পুরোটা দিয়ে দেবে। Paragraph. The present appeal has been disposed of. No.
Yes, yes, SLP has been disposed.
SLP was
This appeal, where you have filed the application.
No, no, no.
appeal pending.
Shumongol paragraph. Shumongol now says that there have been further developments in the matter which would show that monies are in fact refundable by DVC to the consumers, including Shumongol.
Which I am disputing, my lord.
Therefore, comma, Shumongol should not be required to secure the 50% of the area charges by way of bank guarantee or otherwise, as was directed earlier. In December, what will happen, you are saying? 15 December or something?
Yes, madam. 15 December, the regulatory commission will decide the actual amount of
I see.
refundable.
Learned Counsel says that around the middle of December, 2025, the regulatory authority, regulatory commission, shall decide the actual amount refundable by DVC to the consumers, including Shumongol. Therefore, until such determination by the regulatory commission, no coercive step should be taken by DVC against Shumongol. Paragraph. Learned advocate for DVC strongly disputes the submission made on behalf of Shumongol. He further says that,
My lord, sorry to interject, my lord. There is an order of the APTEL subsequent to that 15 September order, which Mr. Chakraborty is relying on 7th of November, which has clarified that this order would be only applicable to those persons who are the members of the association who was the appellant before the APTEL. This is that 7th November. I fear they will carry this forward, my lord, and then, my lord, DVC stand may not be, my lord, that if lordship takes note of this order.
I will order the copy to the
And there is no link with that, my lord, previous order of 15 September with the present, my lord, arrear dues under the, my lord, order of the Supreme Court. Kindly takes, my lord, internal page 6. My lord, the first paragraph at the top, my lord, starting with the relief sought for. People tried to link that they are saying, my lord, under 2009 to 14 tariff period, we are entitled to refund. So don't ask us to pay now, adjust it.
We are not.
This is exactly what the APTEL has said, that you can't link both together.
No,
and
we are
it's
not
separate.
parties.
And my lord, APTEL has further clarified in last page of the order, last 3 lines. This order shall not disable second respondent, that is DVC, from proceeding against other consumers for recovery of the amount due in accordance with law. He is not a party to the association.
I'm not a party. Then, my lord, if I'm not a party, how can an order be passed against me? I do not understand, my lord. But I am saying that I am entitled to some refund for a different period. But I have not hide that fact. For a different
not
period.
comply with the order.
Well, then I will face the consequences.
The Appellate Tribunal for Electricity, APTEL, APTEL, has passed an order dated November 7, 2025 in an appeal carried to it by the Damodar Valley Power Consumers Association, being APL number 307 of 2022, the effect of which is that DVC will not be prevented from proceeding against consumers who are not members of Damodar Valley Power Consumers Association, for recovering amounts due from them. I am just recording this submission.
This appeal is in connection with 1820. My grievance is in respect of 1718. This is this appeal. No, separate appeal.
Learned Counsel further says that passing any order on the present application will amount to modification of the we'll go contrary to amount of modification, we'll go contrary to the order dated with Supreme Court order May 26, 2025, passed by the Honorable Supreme Court. Paragraph. Having considered the rival submissions of the parties, we are in agreement with learned advocate for DVC to the extent that it will be wholly inappropriate for us to pass the orders as prayed for in this application as the same would be contrary to the Honorable Supreme Court's order dated May 26, 2025. Stop. The Shumongol, needless to say, Shumongol will be at liberty to approach the Honorable Supreme Court for appropriate relief.
I'm grateful.
He's so happy with the last line.
I'm grateful.
Lordship has not decided the
on the
merits of
same
the
issue. No, interim. But on the same issue, there are two other applications. On the same fate will happen. Same issue.
Where are those applications?
The numbers can be given, and Lordship, this order can, my lord,
My lord,
cover all three applications.
One by HP
Unless
is
they are listed, Mr. Chakraborty, we have some. They won't be able
it's
to.
better, my lord, we come second day. For all it is better come second day.
Grateful, man.
I'm grateful.
On the way, once those are listed, bring a copy of this order.
Yes, yes.
Granted, disposed of.
Deeply obliged, my lord.
Since we have not called for affidavits, the allegations in the application are deemed not to be admitted by the other parties.
Grateful.
Please, your lord.
I am for the response number 7.
You are for
Response number 7.
7.
Yes.
How many respondents are there?
That 1 to 6 is the union, 7 is an officer of the union, my lord, against whom there were specific allegations. He has contested the matter independent of the unions.
1 to 6 is the union.
Yes,
Union
ma'am.
means, my lord, Union of India.
I find, my lord, in the cost title there is some difficulty.
Gender Sensitization and Internal Complaint Committee.
Yes. That is how it has been described in the cost title of the main proceeding.
You are the appellate.
Yes.
What is the designation of
There was a direction, my lord, to file affidavits, my lord, in connection with section 5.
Oh, there's a section 5.
Yes.
Yes, yes. There's a
Yeah.
section 5. I indicate to your lordship what the section 5.
More than, my lord, 1 year, my lord, delay.
24th April 2024 is the order. My lord, I am an alleged victim of harassment at the instance of the private respondent. Now, whatever little that we have learned from your lordship, while at this side, this sort of conduct by whosoever, I do not want to wash linen in public, but conduct of some person, some of, or any one of us, was grossly improper, which resulted in this inordinate delay. We have, and I do not want to really say something on merits of the section 5, then I have to, show your lordship, the
Here your lordship is looking at a case.
पूरा file FIR.
FIR also resulted, my lord. There was a counter FIR, and the counter FIR, my lord, he wanted to proceed. He, in fact, came to your lordship's court. He has, my lord, enclosed those orders made by your lordship's court in the criminal revisional jurisdiction, my lord, which discharged him from his liability. The matter traveled to the Honorable Supreme Court. The Honorable Supreme Court chose not to interfere, my lord, in the Honorable High Court's order. So the matter has been put to rest insofar as my complaint is concerned. And, my lord,
So no
incidentally, one of the reasons,
No charge sheet was filed.
yes, charge sheet was, but one of the reasons which persuaded the Honorable
Was it-
Supreme Court as well as this Honorable Court to pass the order was the judgment and order which your lordship is looking at. Now today,
All affidavits were invited with the length.
yes, yes.
Connection with section 5 that has been
No, affidavits in connection with the,
Writ petition,
yes, the affidavits in connection with the writ petition was
But we have not.
invited.
not filed.
No, it was invited. It was there. It was
Also-
filed also.
Have you annexed all papers to your stay application?
My lord,
Your writ petition was dismissed, Mr.
Lord, my writ petition was dismissed.
So we will hear out the appeal.
Yes, that is what I am saying.
Mr. Trivedi.
My lord, deepest of respect, my lord.
Yeah.
2024 judgment of the Honorable Supreme Court, followed by 2025 judgment of Honorable Supreme Court. Says, my lord, merit will be taken into consideration later. First, let them cross the hurdle of section 5. Now, my lord, our contention is, my lord, that initial writ petition was filed after a considerable delay. Then, my lord, there is a colossal delay of more than 1 year in this petition.
What is the
And the explanation is neither here nor there in my respectful submission. It has been said two things. One, allegation on the learned advocate. That first learned advocate stated that there is no merit. Then another learned advocate was taken on record, and the lady was not satisfied. Subsequently, there too, the present learned advocate on record was consulted, and then there was a petition, and then coupled up, the icing on the cake is that she underwent a divorce, and
No,
she
that
has
is not one of the. that-
icing on the cake, my lord. I'm putting it very, very firmly. It's icing on the cake. The main
That's actually written in the petition.
lordship, if my lord allows me to place it, and then we have taken, now, my lord, my contention is merit will taken into consideration as far as the judgment of the Honorable Supreme Court is concerned, my lord, if they give us sufficient cause.
That's
And the
fine.
negligence should be, it should not be treated as an eyewash. So, my lord, therefore, my lord, we did not use an affidavit, though it was not categorically stated in the order with regard to the main writ petition, appeal,
Where is
stay
it?
application.
Section 5 ta kotha hai?
10-1.
20 days delay.
My lord, according to us, 386 days.
Mr. Trivedi,
Lordship.
stamp reporter says delays of 20 days.
My lord, that was pointed out by the earlier coordinate bench, my lord, because my lord, stamp reporter possibly, my lord, calculated the delay, my lord, mistaking, my lord, the year of, my lord, the order was order dated.
My lord, I indicate to your lordship, my lord. My lord, perhaps, my lord, the stamp reporter's report is incorrect, subject to correction, my lord, because the order under appeal is 16th of
Obviously,
April
obviously.
2024,
An appeal was presented on 1st of August
2025.
Obviously.
So, my lord, I take it, my lord, that there was a delay of more than 1 year.
More than 430 days. Yes. Yes, let us see what you have said in your section 5.
Please see from paragraph 3.
See, Mr. Bhattacharya, the point is, you know that better than us. This kind of drafting, the appellant was informed when not stated. Very well. Informed by her erstwhile advocate about the order dated such and such, when informed, not stated. Thereafter, having gone through the order impugned, when not stated, approached her then advocate on record, when not stated. So, totally vague.
April 2024, the judgment and order under appeal is April 2024.
Thereafter, this, that won't do, Mr. Bhattacharya.
The exact dates, my lord, at this distant point of time, my lord, kindly pardons me. My lord, I take it on myself, my lord, that it
Never do that. It's not your case. Never do that.
No, I take it on myself, my lord, regarding these pleadings. My lord, I have to, my lord, vouch for it. My lord, what happened is, my lord, after this point of time, first of all, my lord, she has had a very rough spell with various advocates. It is, my lord, I do not want to, my lord.
Very easy to make such allegations.
No, my lord, kindly sees paragraph 5 once I stop there. My lord, unimaginable on the part of any particular, my lord, member of our fraternity, my lord. She is not from Calcutta, first of all. She is from Andhra Pradesh. He travels all the way. Karnataka. He travels all the way, goes through the papers, decides not to file the appeal. For whatever reasons. There's an email correspondence, my lord, regarding, my lord, I did not, my lord. It is, yes, undoubtedly, my lord, I really did not want. Ultimately, my lord, it was sometime in the month of April that she could contact the present set of, my lord, advocates, and ultimately, my lord, the matter was put to rest and immediately steps were taken. We were not even handed over papers. My lord, we had to apply for certified copy of the entire records, resulting in some delay.
When she got into service,
She got into service in 2013.
and
And she,
retired.
yes, short service. It was short service.
Coast Guard women.
Coast Guard women.
Short service commission.
Yes. In the Coast Guard. It's a disciplined service, my lord. Now, if your lordship goes into the merits, my lord, I can.
No. I want to know whether is it voluntarily retired from this service?
No, not voluntarily. My lord, owing to the situation prevailing, my lord, she herself, my lord, decided to.
When such allegation was taken place?
My lord, she made the allegation in 2019.
Why?
2019.
Before the internal committee.
Yes, before the internal committee. Before that internal committee stage, my lord, she first leveled the allegations.
Allegation against the advocates.
And this concern.
Any complaint to the Bar Council?
Not yet. Not yet.
Obviously.
But the allegations are not such that complaint will be made to the Bar Council. She was not satisfied with the draft of the appeal. This is what the statement on oath is. There were several exchange of drafts, but she was not satisfied. She was not satisfied with the decision or the opinion of the first advocate that appeal should not be preferred. Second, several drafts were exchanged, but she was not satisfied. And subsequently, when the matter came to a truce with the recent learned act.
When Lordship is taking up, my lord, the section 5, Lordship kindly come to page 16.
একবার ওনাকে বলে নিতে দিন না একবার ওনাকে বলে নিতে দিন পুরোটা না you complete তারপর আপনি আমরা বলি নাহলে পিস মিলে বলে তো লাভ নেই।
Page 16.
Yes, my lord, serious allegation is there. This learned advocate, my lord, should come and affirm an affidavit.
What's serious?
Rupees 5 lakhs, my lord, was my lord, as per email.
Yes, so
Communication.
5 lakhs, what's wrong?
No,
If
5
the
lakhs.
advocate says that my consolidated fee.
Yeah, now kindly come to page 7.
Page?
7, paragraph 7, page 6. Made payment, did not do anything.
Yes, Mr. Bajaj, anything else?
I leave it. My lord, the thing is, my lord, if your lordship,
She is not a little old lady staying in villages. Rafiq.
my lord, kindly, my lord,
An
on this
educated-
ground, my lord, she is a, my lord, then I kindly permit me to supplementary affidavit দাও তাহলে পুরো details দাও। My lord, then kindly permit me to use a supplementary affidavit. My lord, I can produce, I have this entire set of emails. What was there, what was not there. My lord, I did not want to. I really tell your lordship the truth. I did not want to bring it to your lordship's notice because, my lord,
With what you have given us, you do not succeed. We are very clear on that.
no, my lord, only this much. Only this much. My lord,
Mr. Trivedi, allow them to file supplementary affidavit. if they
Whatever
can.
falls from your lordships, I have no. But my lord, as of now, my lord, as far as this affidavit is concerned, my lord,
देखो, the delay in presenting this appeal is substantial. Stop. We are not, the prima facie, we are not satisfied with the purported explanation furnished in the application for condonation of delay. Paragraph, Mr. Bhattacharya, learned senior counsel,
no, I am. No, I will.
learned counsel representing the appellant, petitioner or appellant seeks leave for his client to file a supplementary affidavit, to disclose further relevant particulars. Stop. Let such affidavit be filed within a fortnight from date. Stop. Reply thereto, if any, be filed within a fortnight thereafter.
lordship.
Paragraph lists the matter 4 weeks hence.
4 weeks hence. My lord, 4 weeks hence, 4 weeks hence.
তারিখটা দাও 4 weeks hence তারিখটা বলো
11th December.
11, ঠিক আছে।
Great.
I'm grateful, lordship.
The only endeavor is to get this, nipped in the bud is because of a separate reason. The reason is, if your lordship goes on merits, perhaps, there is a case to argue. No endeavor given to the person complainant to cross-examine any of the persons who were examined. No endeavor. A group discussion takes place, in the form of ICC.
I assure your lordship, I am as strong on merits as under section 5.
Once you cross the hurdle, we'll look
Yes.
into it. But as of now,
Yeah,
you are 1 point down because
we are
you
1
lost
point
before
down.
the learned.
Maybe 10 points down because, I really, I cannot, certain things, cannot be said. Great.
My lords, please.
29.
I'm for the writ petition and respondent, my lord. Respondent number 7.
I'm a developer who has developed, my lord, a large commercial complex in Shonarpur. Now, development is complete. Now, my lord, in the sanctioned plan, there were 289 cars.
1 second.
Yes,
You are Rajamuthaiya Paramanandam.
I have not been respondent number 8. We added respondent.
Porag.
They are my principal adversaries. Or really my only adversaries.
No, state has also given a report against him. State আছে, state তো নেই রে। State আছে তো?
আমার hyperlink করা নেই এখান থেকে।
Matter has not appeared before the learned single judge.
After
Direction-
that order.
Direction was that the matter will appear in the monthly list of November. Pending before the learned judge.
Yes.
Due to change of determination, there was
Affidavits are complete before the learned judge.
yes.
Everything. Affidavits have not been completed.
Now, you the police continue to maintain the property.
Order that was passed, your lordship will get at page 560, which has not been challenged by my friends. This is a continuation of the initial interim order passed, which has not challenged.
Now tell us, you have not challenged the initial order.
No. That story is this, my lord. We made a large housing complex and we have sanctioned 289 car parking spaces. I am told out of 289, 2 are unusable. So, my lord, 287 car parking spaces. Now, my lord, whoever wants to buy a flat also wants a car parking space. So, my lord, we allotted 89 car parking spaces beyond 287. So 89 people can't have car parking spaces in the house. So what we did was we bought an adjoining land and gave the allotted car parking spaces over there. Everybody was happy. My lord, total is 450. I'm sorry, my lord, 524 flat owners. 522 are happy. There's no problem. Just, my lord, respondent numbers 7 and 8 were unhappy. Out of which, my lord, respondent number 7 has a little reason to be unhappy because his car parking space is outside in that adjoining land is, my lord, it's adjoining the complex. So it's the same premises encircled by a boundary wall. You have to walk across. It's not under the stilt. Respondent number 8, I am told his car parking space is within. So he has no reason to be unhappy. Now I have to set up a maintenance association. So I, my lord, filed a Form A in the before the competent authority. There, my lord, he had already made filed an objection, saying that how can you, my lord, frame an association without amalgamating these two plots of land? Unless these two plots of land are amalgamated, you can't apply. That became the bone of contention.
Who raised this objection?
7 and 8. 520 are 7. 522 people are happy. It's within the complex. Normally developers run away. This is a developer who felt the need to, my lord, purchase additional land next to the original plot and, my lord, encircled it together by a boundary wall and allotted it to everybody. 522 are happy, 2 are unhappy. Out of which, my lord, 1 has no reason to be unhappy.
Who are the people behind this prudential? Who are the people?
Behind. Oh, my lord, Ravi Khetan, my lord, Pioneer Property Management.
I just ascertain whether I know them or not.
Lordship, they do, my lord, I think their largest brokerage organization in Calcutta. Also, my lord, industrial brokerage for warehouses, etc.
Mr. Chaudhary, 12 o'clock we have, is Mr. S.N. Mukherjee here? We had fixed his matter at 12 o'clock. Then we'll unfix it. Yes. What else? What can we do?
For the
We'll
respondents,
rise
I'm there,
for
my
5
lord.
minutes.
For the respondents, I'm there, my lord, in that matter. 12 fixed matter.
Once he comes, we'll take up that matter. You come back tomorrow then? Kalki. Tomorrow. Monday. Very well. Monday, this
whole
with a-
problem, I'll just one sentence more, my lord. The whole problem is, I am told that I have to continue to maintain this whole society and, my lord, subject to payment being received. But, my lord, that is, my lord, nebulous, because if 60%, 70% are paying, I'm a responsible developer. 40% don't pay, I can't abandon it and go away.
No.
It's not possible. So the order directs me to maintain, and, my lord, it's unworkable because a lot of people not paying.
we will protect you. We'll say if even 2 persons don't pay, you need not maintain. We'll do that. Think about it.
Yes.
Everybody has to pay, Mr. Banerjee.
Absolutely.
We will not interfere with the order.
Court has said subject to payment of maintenance.
No.
Now, already mentioned that.
But again, we will clarify. Even if 1 person doesn't pay,
No, what?
Because he will, my lord, because the
That can be done, my lord, your lordship knows.
no, but common areas, he can't disconnect common areas.
Common areas, my lord, the
Facility
what had
to the
happened, I'll
particular
tell your
units.
lordship what had happened.
Banerjee, we are not interfering. We are clarifying. The matter is pending before the learned single judge. It has not been finally decided. So we are not setting aside the order. We clarify that he will have no obligation to maintain if he doesn't receive the charges from all the persons. That is all.
It is the duty of the developer till formation of the owners association. He will have to maintain. That is
So you
statutory
will
mandate.
say,
That
you
is
will
statutory
raise-
mandate.
you
Says
will
you are
raise amalgamation.
creating obstacles. He is saying you are creating obstacles.
Only two.
No, the court has passed an interim order that formation is stayed because of the fact that what they have done, my lord.
Court has stayed the formation.
Yes, there's an interim order that is not under challenge. Court has said formation of association is stayed till the disposal of the writ petition. That they have not
The
challenged.
reason, my lord, the reason
That they have
is
not
this-
challenged.
I have referred.
That is it is a fallout of that order, my lord.
That we will have to consider tomorrow.
My lord, the reason given is that these two plots are not amalgamated.
Look,
So
You
he's
have
going
not
to,
challenged that order.
and I
They have not
can't, my
challenged.
lord, and I can't do it, until the time his assessment is done. So he won't, my lord, do mutation in his name, and I won't get amalgamation.
No, assessment has nothing to do with, my lord, formation of association.
Your client should have challenged that order.
Only one thing they have to do, my lord.
There is
It's the
no challenge
adjoining
to that
land.
order. There's a finding, there's an order staying the formation of a, and your client has not challenged it.
No, that's an interim order staying the form.
Whatever it be, it is not their fault. We
But
can't
they
say
are
it's their
obliged to, my lord, pay even if, my lord, maintenance association is not formed. They can't receive maintenance for free. 70 lakhs is due today, and we are incurring
That we will
expenditure of
clarify.
30, 40 lakhs a month.
That we will protect your pocket.
Yes. Needs protection.
Monday, Lekho. This appeal is directed against an judgment, an order dated September 11, 2025, passed by a learned single judge of our court in WPA 1584 of 2025. Stop. The order is interim in nature in the sense that the writ petition is pending before the learned single judge. Stop. By the order impugned, paragraph for it. By the order impugned, আজকে কি সব তুমি তো নতুন ভাই তোমায় দেখে নিতে হবে হ্যাঁ কোন কোর্টে ছিলে হ্যাঁ কতদিন করছো ও অনেক দিন হয়ে গেছে বেশি ভুল by the order impugned, the learned single judge has directed the appellant oblique developer to continue maintaining the concerned property subject to the charges being paid by the flat owners. Paragraph we have heard Mr. Chaudhuri, learned senior counsel who has come from Goa for some time. It has come from Goa to Likona. For some time, Mama. Stop. Paragraph on the request of Mr. Chaudhuri, Mama, we let this matter be listed again.
Milord, it's December, Milord.
Huh?
Approaching.
Sorry?
Milord, December is approaching.
Only December.
Now, Milord, so tempted.
Monday date to the Monday date to the as the number one item under the same heading. লেখুনি তো গোয়া পা
Lordships, with the kind leave of my learned senior, my lord, may the second call be given a chance, Lordship. That's passed over matter, Lordship. Item 20.
Fixed at 12 o'clock, Mr. Gali.
Item.
Can't be done.
Tomorrow, he will be committed to civil prison tomorrow, Lordship. Lord.
Pay without prejudice, pay.
Lordship.
Na, দেখো, করো।
Specially fixed matter, item number 115.
Then, Mr. Gali, we do one thing. দুটোর সময় কিছু fixed নেই তো। Come at 2 o'clock. This bench is available till 3 o'clock. Sorry, I thought it's from, the other bench is from 2, but the other bench is from 3.
The 2 o'clock, Lordship.
Come at 2 o'clock.
No, I was there. Other side was not there, sir.
Where's your other side? Bring him.
He's here now. I could get hold of him.
Bring him. Come at 2 o'clock. Come at 2 o'clock.
Why you are not there? Why you are
No, tomorrow is the day before the single bench. I'll be committed to civil prison.
You be busy anywhere you want to. At 2 o'clock, we are hearing the matter. It's entirely your choice whether you will come or not. Yes.
Now, my lord, I had, my lord, if your lordships take the list of dates, my lord, I was towards the end. My lord, item 14, my lord, in the list of dates. My lord, the downgradation order of 2nd January 2025, I had placed, my lord. And my lord, I had, my lord, indicated to your lordships.
তোমাদের এই দড়ি সিস্টেম খুলে দাও।
My lord, I had, my lord, 4 NBs, my lord. Those are the 4 points.
Serial number? This is serial number?
14.
14.
That's the order, my lord, which
Yes.
was challenged in the first writ petition.
Yes.
So I had drawn your lordship's attention to this, my lord, that there was, my lord, no finding with regard to, my lord, any deficiency or, my lord, quality, my lord, which had been, my lord, made the ground, my lord, for this. And, my lord, it required a finding to that effect, which was also not there. And, my lord, the design parameters also, my lord, there was no, my lord, finding that it's contrary to the design parameters. We also filed an appeal, my lord, in the grounds we had stated were the very same that were, my lord, in the writ. Then, my lord, the first writ was filed while the appeal was pending. Then, my lord, status of appeal was directed to be disclosed. My lord, date 18/25th, Honorable High Court by another order directed respondent authorities to consider and dispose of the appeal. Then 20th March, respondent 4 issued its decision in the appeal preferred by the appellants without giving an opportunity. That order was set aside. And, my lord, decision was to be taken, and there was an interim order which I had placed earlier, my lord, which said, my lord, that I'd be treated as, my lord, an approved vendor. The downgrading, my lord, would not be given effect to. Then, my lord, 6 June 2025 is, my lord, the final order which was passed, my lord, in the appeal. My lord, in, my lord, the appeal, my lord, and, my lord, the second writ was filed, my lord, that's item 23. And, my lord, that was, my lord, also, my lord, disposed of. And, my lord, even as far as the appellate authority order is concerned, my lord, we have indicated that, my lord, nothing with regard to, my lord, design or, my lord, any defect, my lord, there are no findings at all, or quality, none at all. It's only that you didn't source it from Slovenia. At, my lord, my joint venture partners, my lord, factory from Slovenia. Now, my lord, 2 or 3, my lord, documents, my lord, I wish to show your lordship, my lord, which are, my lord, the terms and conditions. My lord, the tenders, which were the subject matter I've shown, my lord, source of supply could be indigenous, and there had, my lord, been an amendment where they said it only imported, my lord, they said no, now only indigenous. So, my lord, it was never, my lord, if I may use the expression, my lord, term of the tender, my lord, where there were no play allowed in the joints. My lord, it wasn't, my lord, to borrow, my lord, the, my lord, language, my lord, in the writ jurisdiction. My lord, it was, my lord, and we are in the writ jurisdiction, my lord, that, my lord, this was mandatory. My lord, there was a play in the joints allowed, and, my lord, that is what had been done. And there was, everything had been tested, etc. Now, kindly come to those conditions, my lord. My lord, page 40, my lord, volume 1, my lord.
Can one.
একটু নোট করছিলাম না তো দেখে নাও একবার।
What I want. 4.12 and all. Let me follow my own brains first before I follow yours. Where is that? My lord, sorry, my lord, kindly come to volume 2. My lord, one. Correct. My lord, page 160 and my lord, page 161. My lord, kindly see, first is 2nd January 2025. My lord, this is the communication. Now, my lord, kindly come to 161. At, my lord, page 175. My lord, your 4.2.1, my lord, kindly see at page 165. 4.2.1. Lordship has that, my lord. One six five.
165.
My lord, I hope the
175.
no, I hope the paper book's been given and not the stay petition.
এই কি দিলে আমাদের? সি পিটিশন দিয়েছো তো।
My lord, 1491, my lord, is the appeal number.
Page.
I have read what I have to. I will show it from here. Okay. Volume 2.
4.1 point.
4.1, my lord, kindly have a look. Oh, sorry, 4.2. Kindly see the heading, penal actions. Your lordships have that, my lord.
Yes.
Now, my lord, what are the kinds of penal actions? Penal actions, following penal actions can be taken against the vendors. Downgradation from list of approved vendors
এই কি
to
1492 দিয়ে দিলেন 1491 first copy is correct second there is copy
91 এর দুটো কপি আছে দুজন জজ সাহেব বসছেন তো দুটো কপি করে থাকবে My lord, I had a suggestion, my lord. I have been trying to get the commercial court at least to do it. My lord, your lordships are aware of it. My lord, my lord, it should be all e-filing. My lord, my lord, files which can be accessed by the court and my lord, the lawyers involved. And my lord, your lordships can carry it wherever, my lord, your lordships go in case your lordships want to read. It's so much easier. And my lord, documents with all this mountain will be cleared up, my lord, from in front of your lordship.
We need to be trained then. At least I need to be trained. I'm honestly saying this. I have a mental block.
I also did have a mental block, my lord, because I was, your lordships would recall, my lord, I used to write, my
Riddle,
lord,
do and
my lord, margin, my lord, was my points. It was usually 2, maximum, my lord, 5 or 10, 5 to 6 pages with the page numbers. And my lord, I wouldn't use the stick-ons. I had, my lord, take, my lord, the old paper which has been shredded
Staple.
and staple it. So that I had the, but that was a big change to make, my lord. It was a huge change.
Who taught you?
My lord, first my lord, I'll give it, my lord, gradually. First, my lord, doing international arbitrations. The law firms, my lord, associates and juniors, my lord, taught me, my lord, that. Then, my lord, once COVID came, and my lord, I had liquid text, I had time, my lord, your lordships recall, my lord, 1 month, my lord, complete shutdown, my lord, I did 5 webinars. My lord, for Madras High Court Bar, Calcutta High Court, Delhi and Bombay. And my lord, this is what liquid text was what I started catching up on. And my lord, now the upgraded version of liquid text takes it to another level. It's, my lord, it's easy. And it won't take, my lord, your lordships permit, my lord, any, my lord, Saturday, if I can come, my lord, to your lordship's residence, my lord, get some good food, my lord, from, my lord, between, my lord, 1 and 2, my lord, it will be, my lord, done.
We may seriously take up this offer.
Yes, I'll do it, my lord. My lord, I was.
We'll request you at the appropriate time.
Yes, my lord, kindly, my lord, because I think, my lord, our courts, my lord, we should not fall back on this. Because, my lord, at the end of the day, what's happening, my lord, the human capital in our state, my lord, is suffering. Because they're all going out. My lord, the last scam that happened, my lord, which resulted in, my lord, the tainted, not tainted, etc. My lord, everybody lost, my lord, their jobs. So, my lord, I had a few people from the village who'd given up central government jobs, which were outside West Bengal, to come and sit the exam, rank, my lord, be employed, and then their appointments cancelled. My lord, they came to me for advice after the Supreme Court judgment, because there was a paragraph. If you have left a central government or any government organization and joined, and your job is gone, you are given the liberty to reapply, and they will take you in. I made all of them do that. They all got their jobs. They're happy. They're not going to come back. They're from my village. They were, my lord, good students. They worked hard, started a young family, and then they lose everything. And for no fault of theirs. No fault of theirs. My lord, lakhs, my lord, sit for these exams. My lord, the dirty, my lord, 2,000, 5,000, my lord, is what, my lord, kills it. And with connivance. It has to be with connivance. My lord, it's worse than, my lord, a synchronized trading on the stock exchange. My lord, we believe in doing the indefensible and then ask people, my lord, to go and defend. With, my lord, trying to be, my lord, fair to their conscience. It's difficult. Advice is not taken, nothing. Now, my lord, frankly, the judiciary is the only, my lord, recourse. Frankly, my lord, in this state. Nothing else. Now, my lord, kindly see, my lord, after penal action, downgradation. Downgradation of vendor from list of approved vendors to list of RDSO vendors for development order posted on RDSO website and delisting of them. So these are the prerequisites now. Vendors can be downgraded from list of approved vendors to RDSO vendors for development order posted on RDSO website, list or delisted from list of approved vendors or list of RDSO vendors for development order posted on RDSO website directly when in case of one or more of the below mentioned conditions, and then the next, my lord. All the conditions have to be qualified by considering the seriousness and nature of deficiencies and its effects on quality of products. My lord, this, my lord, qualifies, my lord, all these grounds. There has to be, my lord, a seriousness My lord, that has to be considered the seriousness of the deficiency. Second, the nature of the deficiency and its effect on quality of products. Then, my lord, kindly come to clause 2. Because here, my lord, it says, well, QAP said you'd source it from X area, you've sourced it from your own factory. Now, my lord, kindly see, major non-compliance of the approved KOP stroke STR stroke specification standards. Now, my lord, I pause here. These words are used interchangeably. Therefore, my lord, they have to relate to the design of the product. And that's what the covering letter of the QAP also says. It's not from where I get it. It has to be as per that drawing, which is one of the specifications. Then, my lord, length, breadth, depth, these are also specifications. Material, these are specifications. Not where I buy it from. Now, my lord, kindly come to, my lord, duration of downgradation. That's at page 166, clause 4.2.1.3. The downgradation shall be for a period of minimum 1 year. Now, my lord, what has happened here? No, my lord, effect on quality, but the downgradation is without time limit. So, in effect, in perpetuity. I am the L1 always because I have the highest local content, which is greater than 90%. I'm saving the railways money. I'm giving them quality products, but railways doesn't want me to participate in the larger pie, only 20%. Now, my lord, third point I make. My lord, if my quality was bad, I ought to have been blacklisted. My lord, quality does not, my lord, know, my lord, quantity. My quality is bad. I cannot risk, my lord, the lives of even one person. These are passenger coaches. In fact, my lord, the order seems to suggest that it's only because you have not sourced it from the area where the QAP revision 2 says you will source it from, you are in breach of that entry and therefore you are being downgraded. Now, my lord, kindly have a look at that 5 point whatever. My lord, page 171. My lord, these are the tests which I am showing your lordship. My lord, before I get on to this, my lord, therefore, my lord, the only ground, my lord, is that I am in breach of the quality assurance plan, not that it's had an effect on quality, etc., though that's a prerequisite to downgradation. Now, my lord, our Supreme Court has held that if it's only a breach of a term or condition, you cannot have any kind of penal action. My lord, kindly take Technoprint, my lord. My lord, this is 2025 SCC online, SC 343. Other side के copy दो. अच्छे.
Yes.
My lord, kindly see paragraph 33, my lord, which is print page, my lord, 24. My lord, 32 also, your lordship will kindly see, my lord. 32 also. We may put it in a slightly different way. Take, for instance, the show cause notice in the present case is the final order of blacklisting. The final order in any case cannot travel beyond the show cause notice. Therefore, we take the show cause notice as the final order, whether it makes out a case for blacklisting. This should be the test to determine whether it is a genuine case to blacklist a contractor or visit him with any other penalty like forfeiture so and so. We say so because once an order of blacklisting is passed, the same would put an end to the business. It is a drastic step. Once the final order blacklist is passed, then the contractor is left with no other option but to go to the High Court invoking the writ jurisdiction under an challenge. If he succeeds before the learned single judge, then it is well and good. Otherwise, he may have to prefer a writ appeal or LP as the case may be. This again would lead to unnecessary litigation in the High Courts. The endeavor should be to curtail litigation and not to overburden the High Courts with litigation present type, more particularly when the law by and large is very well settled that there is no scope for further debate. So, my lord, now, my lord, here, that's exactly what has been done to me. As observed by this court in Eurasian equipment, an order of blacklisting casts a slur on the party being blacklisted and it's stigmatic. Given the nature of such an order and the impact, therefore, it would be unreasonable and arbitrary to visit every contractor who is in breach of his contractual obligation with such consequences. So, if it's only a contractual obligation, no. Cannot downgrade, no penal measures. Now, Miller, the power to blacklist cannot be resorted to when the grounds for the same are only breach or violation of a term or condition of a particular contract and when legal redress is available to both sides. Else, for every breach or violation, though there are legal modes of redress and which compensate the party like the corporation before us, it would resort to blacklisting and at times by abandoning or scuttling the pending legal proceedings. Then, my lord, plainly, if a contractor is to be visited with punitive measures of blacklisting on account of an allegation that he has committed a breach, the nature of his conduct must be so deviant or aberrant so as to warrant such a punitive mere allegation of breach without anything more. Now, my lord, assuming I breached this, because I said I haven't got it from there. So, I'm breach of a condition. Normal rule, my lord, is, my lord, that they're entitled to damages. Now, my lord, can they prove, my lord, damages here? They've got it at a cheaper price and it's functioning without defect, without, my lord, any complaint, without any dispute. Token damages 1 rupee.
In these kind of contracts, it's not so much monetary compensation, it's public safety.
Correct. So, my lord, here public safety, it has to be, my lord, the finding is, my lord, contractual, not that public safety was compromised. And the learned judge has also said, my lord, that you have deviated from the contract. And I am saying, my lord, specifications. My lord, the QAP specific, they all have to be read together. My lord, QAP, my lord, has been described. That's a design feature, which is the drawing. Then, my lord, the tender may say, my lord, what material? What would be the dimensions? Those are specifications which put lives of people at risk. And here there was no question of that also, because kindly see now what happens. My lord, kindly go back, my lord, to, my lord, clause 5.1 at page 170. In fact, I should start from 5, my lord. Kindly see the heading. My lord, as I said, first there is an inspection of what I am to supply. My lord, then my lord, 5.0 at page 169, my lord. Picking and testing of samples from the lot already passed by the inspecting agency in the vendor premises or from consignee end field. So, my lord, there is a testing. Testing procedure, my lord, is also mentioned. In the above case, following shall be ensured during picking and testing of samples. This is mandatory. My lord, jointly, my lord, samples have to be taken and they have to be coded. Then, my lord, the number of samples to be picked, 2 samples. First sample is for testing and second sample shall be standby sample which shall be tested in case of any complaint or if directed by the special so-and-so. Standing sample shall be kept in a newly created directed so-and-so. Now, my lord, after all this, kindly come to the testing procedure. 5.1. My lord, testing of sample, page 170. Action to be taken based on test results. In case the first sample passes, the same shall be intimated by the design or QA directed to the field office from where the sample was picked up. If the first sample fails, following action to be taken. In case sample fails marginally in maximum 2 parameter by less than 5% from prescribed values, the RDSO shall intimate the consignee inspecting agency to take action for rejection. If sample fails in more than 2 parameters or in 2 parameters by more than 5% from prescribed values, then besides action for rejection, penal action shall also be taken. So, my lord, mere failure of sample, my lord, is not good enough. My lord, failure, it has to result in rejection. And the failure limit is, my lord, 5%. Over 5%, then, my lord, reject and penal action. Then, my lord, in case sample fails in 1 parameter by a large margin, greater than or equal to 10% from prescribed value, then besides action for rejection of lot as per para 1, penal action also be taken as per clause 4.2. However, the severity of penal action shall be based on the degree of non-conformity. So, my lord, whether 1.5 years or whether 4 years, whether 5 years or whether in perpetuity. If 100% of the sample, my lord, is bad, one consequence. My lord, if, my lord, 8%, my lord, is, my lord, bad, my lord, one consequence. But the important point is, it has to fail the test before, my lord, penal action can be taken. Now, my lord, here, no test has been failed, yet penal action has been imposed. And there is, my lord, no finding with regard to, my lord, any, my lord, defect in quality. And that,
Yes.
yes. Then, my lord, kindly note, my lord, in this case, factually, there has not even been a rejection per se, my lord, only a rejection, which is, my lord, of a category below that of, my lord, penal action. All items consumed, all items paid for. And the railways have saved, my lord, a huge amount of money. Question is, my lord, somebody playing a game? Now, my lord, 172. My lord, when, my lord, penal action is taken, my lord, the critical parameters, my lord, have to be mentioned. Lordship will find that at 171. And then in 172, after indicating the parameters, when indicating, not after, when indicating the parameters, my lord, a very important thing has to be done. Kindly see the note. Specific comments and quantified details have to be given against all four criteria to establish degree of non-conformity while deciding the quantum of penal action. Totally absent. I got it from outside, or I got it from my own factory, or I didn't get it from Slovenia, I got it from Germany, or I got it from a factory belonging to another Indian manufacturer. But it's in line with KE drawing number so and so. Hello, the deviation has to, did it fail a test? Was any item rejected? No. Naturally, therefore, there could not be a deviation in greater, less than or greater than 5%? No. None is mentioned. Only thing is you didn't comply with this. Now, Millard, that's it on facts. Anything else on facts? Now, Millard, kindly come straight away to one judgment. I'm sorry. Proportionality, one, Bombay.
Yes.
My lord, the first case I wish to rely on, my lord, is 2014, 14 Supreme Court cases, 731. Yes, sir. My lord, this case I cite, my lord, on the issue of proportionality, because it's, my lord, without, my lord, a time limit. Kindly see paragraph 17. My lord, placitum C, 2 lines above that. This implies, your lord, I'm sorry. This implies that any such decision will be open to scrutiny, not only on the touchstone of the principles of natural justice, but also on the doctrine of proportionality. Then, my lord, next, my lord, last 2 lines of that, my lord, paragraph, para 17, the order itself being reasonable, fair, and proportionate to the gravity of the offense is similarly examinable by a writ court. Then, my lord, kindly take paragraph 26. My lord, here there was a permanent debarment in Kulja, my lord. Kindly see para 26. 4th line. Permanent debarment from future contracts for all times to come may sound too harsh and heavy a punishment to be considered reasonable, especially when the appellant is supplying bulk of its manufactured products to the respondent and the excess amount received by it has already been paid back. Yeah. My lord, it's the same principle. My lord, in my lord, Isolator's case, which is a later decision, 2023 8 SCC, page 607. Para 38.2, my lord. Maximum penalty, my lord, has been, my lord, imposed. Now, my lord, 39 is very important. Page 630. Last 4 lines. Moreover, no specific quantum of loss has been specified by the respondent so as to justify imposition of maximum penalty. Impugned order has to be. Now, my lord, here it's already, my lord, almost a year. My lord has, my lord, passed. Now, my lord, now, my lord, one decision, my lord, of the Bombay High Court I wish to rely on. My lord, which was a railway matter. My lord, 2023 SCC Online Bombay 350. My lord, this was a case. My lord, I'll just indicate the paragraph numbers. Very well, my lord, I'll just place the paras. My lord, here, my lord, the writ petitioner was, my lord, a supplier of overhead equipment to the railways. It's a major supplier. And, my lord, it was delisted for 9 months from the approved vendor list.
Cite this stop for the 1245.
Oh.
Fixed.
Oh, I see. I'll just cite this, my lord. The challenge is to a delisting letter of 10 November at exhibit. Effect of it is delist.
Lord, I may come back tomorrow or some other day because that's not an urgent matter. 12:45.
Other side is saying it's
As you wish.
No, if Mr. Mukherjee has no other work for the present, he can continue.
Will you finish by 1:15?
I'll try to, my lord. I think I should.
Then when will you come back? Tell us.
Any day tomorrow. It can be tomorrow also.
দেখো খাতা খোলো। কালকে 12:45. Tomorrow 12:45.
12:30
না দেখো কবে আছে Monday 12:30.
Monday
12:30.
Well, I'm great. Thank you.
Which para are you placing?
Para 4, my lord. The challenge is to a delisting letter of 10 November at Exhibit A, page 79. The effect of it is that the petitioner is delisted for 9 months from the list of approved vendors for the manufacture and supply of jointless, hard-drawn, grooved copper contract wires or HDGC. Show cause notice is also assailed. Then, my lord, there was a quality assurance plan, para 6, Lordship will find. So para 4, para 6. Now, my lord, kindly see, the source was identified. Kindly come to paragraph 8. Now, important thing is, in our case, my lord, nobody is an approved supplier. Approved supplier is left blank. But, my lord, source from outside, my lord, one particular item, my lord, from, my lord, Slovenia. Now, kindly see here. As our 20 order notes, one of the raw materials for manufacture, HDGC wires, is what are called CCC rods. These must be purchased from an approved supplier. An approved supplier of CCC rods is Hindustan Copper or HCL. In turn, copper cathodes are used in the manufacture. To trace this in reverse, copper cathodes are used to make CC rods, and these CC rods are then used to make HG. While there is quality control and manufacture to specifications required throughout, copper cathodes must conform to the requirements of the London Metal Exchange Grade A spec. The only charge against APAR Industries is that it got copper cathodes from a third party and supplied these to HCL to manufacture CC rods. APAR Industries is accused of engaging in what is described as job work. It is true that APAR bought the copper cathodes from Sumitomo as these met the required London Metal Exchange Grade A specification. Fourth respondent is Rail India Technical and Economic Service or RITES. It has inspected CCC rods and aged and certified these as meeting quality, as here. My lord, the matter had gone to arbitration here as a dispute. Now, my lord, kindly see para 18. On the face of it, the impugned order cannot be sustained. Delisting for any period of time has serious consequences. As a matter of administrative law, no order with such consequences can be made in what is the purest speculation. Nowhere in the papers to be found a single record to indicate that there has ever been a deviation from specifications of quality, or two, that because APAR supplied Sumitomo copper cathodes to HDL for manufacturing so-and-so, after it could make HA, there has been any degradation, deterioration, variation or fall in prescribed quality or specification.
It showed no prejudice at all.
None.
That's what.
None. And they paid for it. They're willing to keep me for 20%. It can't be. I who give the lowest price, my lord, will only compete in 20%. And that too now, when I have QAP revision 3, which my lord recognizes that I can manufacture here. All quality controls are being met here. Then, my lord, we understand the prohibition of prosecution against prescription. The reason is self-evidence. It has to do with quality control. But the mere fact that a person has obtained copper cathodes from another vendor and sent them to HCL for manufacture does not inevitably lead to a factual conclusion that there has been a variation in quality standards. This is one reason we find that the impugned order at page 79 could not have speculated as to what might happen. If there was to be a blacklisting, this could only be done on the basis that there was indeed and in fact a deterioration in quality. Once the supply was found to be non-conforming in quality, then it really would make no difference why that non-conformity took place. It could then be perhaps attributed that Sumitomo cathodes are being supplied, but this is a factual determination, etc. Now, my lord, kindly have a look. My lord. One minute. Strangely, the impugned order makes para 22 makes reference in its subject lines to these RDSO specifications with effect from 1st January, but applies them to supplies made between 19 and 20. That could never have been done. Then, my lord, lastly, on the following as factual aspect of the matter, following points must be kept in mind. My lord, if at no point has the railways rejected the wires manufactured in this manner by APAR, on the contrary, these supplies have been accepted, actually been used for some reason that we cannot understand, offered to replace. If they were compliant, that there was nothing. APAR shouldn't have done that, but my lord, this is what has happened. On this basis, my lord, the entire, my lord, order, my lord, was set aside. Now, my lord, here, kindly take the order of the learned single judge. My lord, volume 4. (481) it starts, my lord. My lord, para 30, now kindly come to para 30, page 489. My lord, third line. The petitioners have admitted that they have not supplied items as per the approved QAP. Whether the item supplied by the petitioners was identical to the approved QAP or not is not required to be ascertained. Railways don't say, they are happy, they've done the test, they've taken it. That meets the technical. Then, my lord, para 31. My lord, last 3 lines. It is absolutely not possible for respondent authority to keep on verifying whether material supplied by a vendor is in accordance with approved standard or not. They are doing it. Inspection, sample testing. And on that basis, my lord, imposing penalties. Then, my lord, para 32. My lord, 6th line, last, my lord, 6 lines from the bottom. Once the petitioners accept the fact of deviating and supplying item contrary to approved, natural corollary would be imposition. Sorry, with the greatest of respect, my lord, that is not so. It has to be a, my lord, design specification. Then, my lord, 33, page 490. This is very important. It may have been that the quality of the item supplied is at par with QAP, but the same is always subject to further checks, rigorous time and inspection. Petitioner cannot trust upon any product not. It's been approved. And my lord, Slovenia factory, my lord, is not approved. Then, my lord, 491. My lord, para 36, continuation. 2nd line. Supply of any item not as per approval would violate to amount to violation of terms and conditions of contract liable to be. That can't be the basis of my lord downgrading. That is my lord technoprint. Then, my lord, kindly see how APAR, which we cited, is dealt with. Para 38, 491. In APAR, the court note took out the prohibitions against job work and RDS enforced prior did not contain such a court was of the prohibition could not have applied. In this instant case, approved QB already in place. I don't think, my lord, that's the only ratio of the case. Finding on quality, my lord, was necessary for, my lord, any, my lord, downgradation or delisting. These are penal actions.
No, otherwise, I'm just thinking aloud for their benefit also. Otherwise, the logical corollary of what the learned judge has said, just because there is deviation, that's enough for you to penalize. What if because of the deviation, you get products of a better quality?
My lord.
Even then you can penalize.
My lord.
Anyway,
My lord.
We are not hearing you now. Just respond to us when you argue.
We'll respond to it, my lord.
Can't be. Some prejudice must be there.
My lord, the case is different, my lord. The entire case is different.
All right. All right.
Now, my lord, I want to show your lordships. For the same item, which is why we've got these documents later, we filed an order 41 rule 27. My lord, and the law is it has to be heard with the appeal. I'll just show those documents. My lord, the favored suppliers, give the order 41. My lord, kindly have a look, my lord, at what application is it? GA কত নম্বর? Order 41 rule তুমি তাহলে মাইন্ডি GA3 application.
Volume 3, page.
GA3 টা দিন আমি পেজটা
Volume 3. Volume?
volume GA3 টা ভলিউম 3 থেকে কিছু নেই ছোট্ট GA3 এই যে দেখো না প্লিজ can 3 সরি ওটা ক্যান বলা হয়
Yes.
now my lord kindly come as an example I'm giving. My lord, kindly take page 25. My lord, section D, my lord, the product, my lord, is there's a quality assurance plan, revision number 5. My lord, my lord, relating to Escorts Cubota Limited. This is also a joint venture. My lord, at the top, your lordship will find, my lord, of this document. QAP, revision 5, and it's Escorts Cubota Limited.
The product here is brake disc.
Disc assembly. Now, my lord, kindly have a look at details of in-house manufactured component sub-assemblies, brake disc assembly. Then, my lord, purchase from RDSO approved vendors. My lord, none. Details of items outsourced from other than RDSO. Kindly have a look, my lord. They are not RDSO approved. And where are they getting it from? Brake disc casting. Name of source. To be reviewed quarterly. Then, my lord, page 13. The lordship kindly goes to. This is the vendor directory. There's an approved vendors list here. They don't come under that. So, my lord, if I procured it from them, it would have been fine. This is not a design specification. Design specification is there.
You're trying to say that against Escorts, no action has been taken.
No, they've accepted. My lord, I'm only, my lord, I don't want to hurt anybody else. All that I want to show is that this is not, my lord, design specification of sourcing it from a place. Because the source is not RDSO approved. The drawing is RDSO approved. So, my lord, here I manufactured it at my own place. I could have got it manufactured elsewhere. And my lord, these are manufactured in India. My lord, for me, it can't be you import. I'm showing, my lord, discrimination. If it was, my lord, a mandatory provision that I had to import, then if that component had to be imported, my lord, it couldn't have been, my lord, local manufacturers, my lord, where they could source it from. Source is not, my lord, a design specification. I'm saying you can do it from anywhere if it's not an RDSO approved vendor item, or, my lord, it's not an item which you are manufacturing. Then all that you need to do is procure it from whatever source, indicate that, but ensure that it complies with the design specifications. And it will be caught out if it does not, because there are tests. There's an inspection first, followed by, my lord, a test, sample test. And these documents, they should have disclosed. Instead of saying it's a mandatory requirement, I have failed to comply with my QAP. My lord, my point is, my lord, the action which has to be taken for, my lord, of any penal nature has to be, my lord, a deviation from specification stroke QAP stroke tender conditions. They have to be of like nature, which are, my lord, specifications. A QAP, my lord, contains a design specification because it's based on a drawing. To have, my lord, a quality assurance plan. Tender may, my lord, give the dimensions, might give the number, might give the material. And, my lord, the tender conditions themselves, my lord, treated it as non-mandatory. I've shown your lordship. First, it started with imported or indigenous. Next had only imported, which got modified immediately to only indigenous. Others were doing it indigenously. In their QAP, it was indigenous, and they are not RDSO approved. The sources which I've mentioned. I've given the vendors directory, their names don't feature there.
RDSO is?
My lord, Research, Design and Specification Organization of the Railways. Now, my lord, whenever, my lord, earlier litigation, your lordships might recall, my lord, prototypes had to be, my lord, built because most of our, my lord, railway, my lord, equipment used to be imported. Then, my lord, in the 80s, it started changing. It started with, my lord, signaling, railway tracks, my lord, certain specifications. Primarily, it was the European countries, and, my lord, the US had, my lord, Smith Stanistreet, I think, my lord, the air conditioner manufacturers also. My lord Smith, we used to see it, my lord, when going through Beleghata, my lord, to the airport, they used to have a little factory, my lord, in Kolkata. Then, my lord, it was primarily Europe. Then they started having joint ventures or technology collaborations. And we have, my lord, the largest market, my lord, for, my lord, railways.
Yes.
So, my lord, they had to come here.
That's it?
No, those are my.
When will you argue?
Monday, my lord.
Monday. By Monday time,
Monday,
12:30, we have just now fixed a matter. Advocate General's matter.
My lord, 12:30 matter is fixed on Monday, my lord. Our next matter was fixed on 12:30.
বলুন মঙ্গলবার Tuesday
Any day, my lord, after Monday.
মঙ্গলবার করবো বুধবার করবো Wednesday 12:30.
Wednesday, 12:30.
My lord, may I check?
Yes, check. Okay. কখন তাহলে মঙ্গলবারই করো Then no, Tuesday, sir.
Tuesday, my lord. I'm grateful, my lord.
Mr. Mukherjee, Commander at Senior Counsel, representing the appellants, concludes his opening submission. Paragraph, as requested by learned advocate for the railways, list this matter once again on Tuesday, date thou, marked 12:30 p.m.
So grateful, my lord.
at the end, a very, very short note.
Yes, yes,
We
I
have,
have it.
we have noted, your list of dates really is in the form of a
Yes, my lord,
notes of
it's,
argument.
so my lord, short note shouldn't be more than 2 pages.
Yes. Now, এগুলো নাও, দেখো হারিয়ে না যায়। এটা তুমি লিস্ট অফ ডেটস এর সঙ্গে রাখো। এই লিস্ট অফ ডেটস আলাদা ফাইল করো। কভার ফাইল আনাও বাবু, আমি বারবার বলি তোমাদের কভার ফাইল আনাও, সেখানে নোট রাখবে, এগুলো রাখবে। Sir, please use the microphone.
Harassment Advocate, the petitioner, respondent hearing, number one, he died.
Respondent number one died.
Died, my lord. I have disclosed the name, my lord, page 132, PLRO, stay application. He also has also disclosed the fact that Radhasam Das Adhikari is deceased now, dated 15th May 2024.
Single bench zero.
अरे बीएलआर के तो जानिए छी गौरव पदार्थ तो हम जानिए छी and also I filed the substitution application. I served the copy, Mr.
Very well, sir. Allow us
Santoni.
to see what the order impugned is.
The dead man is the party. That is why I mentioned the matter. Impugn order, my lord. बोलो
बोली Milord, may I place, Milord, a few orders, Milord? Order was complied with.
Belatedly.
Belatedly.
And with short notice of the hearing.
Milord, the
there I want to. My lord, thereafter another order, my lord, 21st May 2002. Two orders.
21st May is not subject matter of this appeal.
Yes.
Where is 21st May order?
the 21st May is 191.
191. Impugn order.
But it's in the memo. Both the orders are in the memo. 17.5 and 21.5.
Are in the memo?
Both are in the memo. But if I may place, Milord, the order dated 17/5/2024 first. Here, Milord, in the second page of the order, kindly take, Milord, paragraph number 6. If my lords are looking from the stay application, then it's at page 189. Please take paragraph 6, Milord, at page 189 or internal page 2 of that order. There is no doubt that there has been inordinate delay of 1 year in complying with the court's order. A belated compliance of a court order itself constitute contempt of court, the so and so, such and such. Then we are at paragraph 9. Since this order has found prima facie contempt on the part of the BLL and LRO, let a sum of rupees 15,000 as fine be deducted from the salary of so and so by the DM and paid to the High Court Legal Services Authority.
Mr. Vedotu, can you arrive at a prima facie finding of being guilty of contempt and fine?
No. It has, Milord, this is a proceeding quasi-criminal in nature. Therefore, Milord, there has to be, Milord, a concrete finding.
Definite finding.
Yes.
The contempt of jail contempt.
And as your lordships have always held, that violation, unless it is coupled with a deliberate non-compliance and willful.
Violation. I have always, in my very few judgments I have written, there must be an element of denial. I will not obey.
Yes.
Sir.
My lord, kindly page now, order dated 21st May 2024.
Correct.
I am paying only, my lord, the latest certified copy 44 pure proceeding by case number such and such and the big route proceeding, my lord. My lord, this affidavit compliance has falsely by making false affidavit, my lord. as because, my lord, kindly see the title suit page. There is no documents. They could not produce any documents.
What is the parent? Which is the parent order, Mr. Datto?
Milord, the parent order, Milord, is no. Just a minute.
Violation of which has been alleged?
Milord, your lordships may kindly take, Milord, page number 111 first. But I'm sorry, Milord, that parent order is not annexed.
It's not annexed.
But it's quoted. It's quoted. Milord, this is Milord 26th of November 26th of November 2022. This reflection would be, Milord, from the order of 15th of March 23, which your lordships would find, Milord, at page 110. 110, Milord, your lordships have found, Milord?
Yes.
Milord, in 110, kindly take me at page 111. Well, a brief background of the facts, Milord, are available at page 111. Milord, the petitioners applied for.
Mr. Datto, let us not spend much time on
Yes,
this. Prima facie, we are of the view you cannot come to a prima facie finding of contempt.
Right.
Fine.
Right.
So we will stay the operation of the order. We'll hear out if he wants to file affidavit, whatever, we don't know. On the next date, produce the parent order. That's all.
Very.
Produce a copy of the parent order.
Very.
Do you wish to file affidavit, sir?
Yes, my lord. My lord, my humble prayer, my lord. Since 1978, my client filed the title suit application. Title suit. In the year 1972, in course of hearing, they did not produce any documents. 44 PA proceeding as well as big route proceeding. Kindly see the page 5, my lord. They did not annex.
Please
That is why, my lord, now they're making the false affidavit, the 44 tier proceeding.
Do you know there is a section called 340 of CRPC, which I don't know what it is now?
Yes, I also don't know.
Look up 340 CRPC, file application for leave to prosecute the deponent. We are only on one thing, sir, whether the BLLRO has committed contempt of court or not. The division bench here is only concerned with that question. What was the direction on the BLLRO? To give you a hearing.
Copy of the 44 PA proceeding as well as big route proceeding order sheet.
To give you a hearing and take a decision?
No, my lord. Kindly see.
Do you have a copy of parent order is dated?
But 15th of March 2023, that is page 110.
No, the parent order of which violation is alleged.
This is 15th March.
This is the one.
Yes, yes.
You said it is not there?
No, the previous order is quoted over there.
I see.
Which is dated, Milord, 26th of November 12. That is not on record. It is kindly take, Milord, page 112.
Yes, it is directed.
In the aforesaid circumstances, the court directs the BLLRs to forthwith take a decision in terms of the decree of the civil court as described.
Correct.
The court is surprised that the BLRO has not taken a decision despite orders of this court passed in the writ petition as also so and so. It is ordered that so and so shall take a decision in the matter of rectification of the records of right in favor of the petitioners applied by them within a period of 1 month from date mandatorily and positive.
Therefore, the direction, please understand, sir, the direction was on the BLLRO to take a decision regarding the rectification of the records of right within 1 month in the light of the decree of the civil court.
Right.
Now, 1 month became 1 year. But ultimately, a decision was taken. Decision may be against you. We are not on that. So there has been compliance, but belated compliance. Now, whether that amounts to a contempt of court or not, we will have to decide. But the learned judge has said prima facie there is contempt and therefore fined 15,000. This prima facie is not acceptable to us. So we are staying.
SWAT.
My
lord, we have no objection to withdraw the penalty. only my lord, my prayer, humble prayer, because in a day, the 46.10 acre land has been vested by the proceeding, by
Sir,
the manufacturing.
that in contempt we can do nothing. Please understand the law. Contempt court is only concerned with আপনি বুঝতে পারছেন কি বলছি কন্টেম্পট অ্যাপ্লিকেশনে সেটা আমরা বিচার করতে পারবো না তার জন্য আপনাকে অন্যত্র যেতে হবে
My lord, order 21st May 2008 be the let the certified college paragraph 5, my lord, kindly see paragraph 5. Paragraph 5, 21st May 2024. My humble prayer, my lord, to supply the copy of the order sheet of the 44%. Otherwise, my lord, I will be beggar.
No,
My lord, 46 total lands have been invested without any service notice. Without any service any notice. My lord, kindly see paragraph 5.
Why don't you do that? Why don't you give him certified copies of the order?
But I'm told, but I'm told me that his client has preferred an appeal, statutory appeal against that, against my rejection.
From that compliance.
Yes.
He's saying, but again, the learned single judge, if you see, look at the
Well, that
21st
direction, Lord, maybe an innocuous direction, but with respect, Lord, in a contempt proceeding, could not have been passed.
maybe, but we
Yes.
are requesting you to hand over. We are staying the operation of this order.
That will be done. Give us some time.
7 days.
Certified copy, 7 days is deals.
Order sheet of the certified copy. My humble prayer, my lord.
They'll give you. We
Yes,
are directing them. We are requesting them. They'll give you.
Yes, ma'am.
Learned Advocate General has assured us.
Yes, ma'am.
You know Mr. Dotto is the Advocate
Yes, my
General.
lord.
You know that, huh?
I am practicing 1985, my lord.
85, you're
Yes,
very
ma'am.
senior.
Yes, yes.
Mr. Dotto was not then there in the profession.
And your lordships are also not there.
My lord,
I was not there for
my humble prayer, my lord, only to certified copy of the order sheet of the big level proceeding as well as 44.
he has
Nothing more, my lord.
ঠিক আছে,
said
ঠিক আছে,
so.
দেখছি,
Yes, ma'am.
This appeal is directed. কি করবো সেটা stay করে রেখে দিই।
But there's a delay of about
কত, how much?
39 days.
Delay which applicant?
Can 1 of 25.
As a cause title, my lord, corrected, my lord, cause title, the delay, the
24.
appellant respond.
24.
No, not can one, Mr. Dotto.
Can 1 or can 2?
Can two.
Can 2. I'm so sorry, Miller.
Mr. Galib,
No, it is transferred brief lordship.
No excuse.
Lordship.
Transfer to এটা কোনো একটা কথা হলো?
39 days. কোথায় 39 days আছে বলে যাকে? Can two, huh? This is an application for condonation of delay in presenting the appeal stop. Causes shown being sufficient, the delay is condoned. Paragraph can two is disposed of. এবারে can one to say করবো করে তারপরে affidavit যদি ফাইল করতে চায় do you want to file an affidavit to the stay application or not necessary?
No, my lord, I will file it.
You will file it. Can one along with the appeal, huh? This appeal is directed against an order dated May 21, 2024. Sorry, bul. Order dated May 17, 2024, passed by a learned judge of our court in WP CRC number 90 of 2024, being a contempt application which came out before the learned judge after issuance of rule. Stop. Paragraph. It appears that by an order dated March 15, 2023, passed in WPA 24484 of 2012. Who is this? Who was this Radhesham Odhikari?
That was something my client, my
Your
lord.
client.
He died, my lord.
Acha, he died. Who is there now? His son.
His son already died, grandson.
Grandson. Who is Dimadhar? Dimadhar, that
Mother is the one brother. Radhasam Das Adhikari, Dimadhar are two brothers,
So Dimadhar is there.
like living.
কি বললো? Being a writ petition filed by the respondent number 1 hearing, comma, who we are told has since passed away, you have to correct the hospital thing, comma,
First time, 15 February
and
2020.
one Dimadhar Das Adhikari, comma. The learned single judge directed the alleged, the concerned block land and land reforms officer, concerned Kirda block land and land officer, comma, Sabang, SABONG, comma, Paschim Mednipur, to take a decision in terms of the decree of the civil court referred to in the said order. Stop. The operative portion of the order reads as follows. Colon দিয়ে page 112 থেকে এই bracketed portion দুটো paragraph খালি। Paragraph. It appears that there was delay in complying with the said order. However, comma, it is not in dispute that when was the order passed by the
Block Land and Land Reforms Officer Millard had passed the order on 15th of May 2024.
not in dispute that by an order dated, that the concerned BL and LRO passed an order dated May 15, 2024 in compliance with the direction issued by the learned single judge. Stop. The contempt application was filed before that.
With the contempt application
Contempt filed before that.
Before that.
before that.
Paragraph. Before the order dated May 15, 2024, was passed, passed by the BL and LRO,
Contempt was pending.
the petitioners had filed, writ petitioners had filed an application for violation, alleged violation of the order dated March 15,
23.
2023. Stop.
For 23 notice.
When the contempt application came up before the learned single judge, the learned judge, when the contempt application came up with the learned single judge on May 17, 2024, the learned judge passed the impugned order,
Millard, 17th of May 24.
impugned order, the operative portion, relevant portion whereof reads as follows. It a memo থেকে পেয়ে যাবে 17th May 24, paragraph 6 থেকে 10. Next. Being aggrieved, the alleged contemptor, I see the contempt application has been disposed of.
Yes.
Yes, disposed of.
Yes.
By holding prima facie contempt.
Yes. And Millard, it came up for correction.
That is a correction only. That's
No, in the correction order, Millard, the additional direction for supply of certified copies were.
that I've seen. Yes. Acha, has come up by way of this appeal. Paragraph. We have heard learned counsel for the parties. Stop. Learned advocate general appearing for the appellant says that no punishment could be imposed on the alleged contemnor on the basis of a prima facie finding of contempt of court. Stop. We quite agree with him. Stop. We prima facie agree with him. Stop. Paragraph. Contempt of the contempt jurisdiction of the High Court is a quasi-criminal jurisdiction. Quasi-criminal jurisdiction. Stop. The court has to be quite sure that the alleged contemnor has willfully violated or disobeyed an order of court before such person can be held to be guilty of contempt of court. Stop. No punishment, comma, whether civil imprisonment or fine, comma, can be handed out to an alleged contemnor on the basis of a prima facie finding. Stop. ঠিক বলছি তো
Cannot be.
Does it make sense what I am saying, Mr. Advocate General? Does it make sense? Paragraph. In view of the aforesaid, there will be a stay of operation of the order under appeal till disposal of the appeal. Paragraph. Learned advocate for the writ petitioner, writ petitioner oblique respondent says that his client would like to file an affidavit in opposition. Stop. Let such affidavit be filed within কতদিন এর ভেতর ফাইল করবেন?
Within 30 days.
4 weeks.
4 weeks.
4 weeks. 4 weeks from date. Date দিয়ে দিও. Stop. Reply thereto, comma, if any be filed within 1 week after the 4 weeks will take us to
Almost the vacation. Well, today we are on 13th, 12th, 11th.
11th. 1 week after the winter Christmas vacation. 1 week after the Christmas vacation. List the matter.
My lord, by this time kindly supply the copy of the order sheet.
আমরা কি শেষ করেছি? শেষ করতে দিন আমাকে। মহা মুশকিল। He is unable to follow whatever I am saying in English. List it ওই করে দাও না। হ্যাঁ? না, monthly list না। 1 week after vacation তোরা ফাইল করবে। তাহলে 10 January February ছুটির দিন না হয় সেটাই দেখো। না, 12 January 12. January 12 কিসের? Oh, 13.
January 12th must be a holiday.
The calendar has not yet been finalized. Ought to
Swami
be.
Vivekananda's birthday.
Should be.
Anyway,
Some years it wasn't.
yes.
13 January, paragraph. We further see that on May 21, May 21, 2024, the learned single judge, post disposal of the contempt application, passed the following direction. 21st May ta memo te ache, para 5 ta.
My lord, Private, there is some mistake. Like in the year 1973, instead of 1972 would be written, my lord. Paragraph 5.
Proceeding number.
Proceeding number, yes, my lord. 44-2A, by case number such and such in the year 1973. It will be 1972.
Very well. Quote করে দেবে paragraph 5 টা, হ্যাঁ?
এই তো big right proceeding number 9 of
Paragraph.
72 ই তো আছে।
না এখানে আছে
No, in the third line, 1973 has been mentioned.
আছে।
আচ্ছা।
Paragraph. Learned Advocate General says that strictly this order could not have been passed in contempt jurisdiction, and particularly after disposal of the contempt application. Stop. He may be right. Stop. However, we request Learned Advocate General to ensure that the order sheets, certified copies of the order sheets mentioned in the aforesaid extracted paragraph 5 are made available to Learned Advocate for the writ petitioners within 10 days.
But I would I would require some more days, because when I asked my clients that why did you not comply, they said that somehow the file has got misplaced. I've asked them to reconstruct the file. You are somehow
2 weeks.
Well,
2 weeks from.
Well, in the year 1972, how is it possible? There is no papers. How is it possible to?
We were not in custody of the papers. We don't know.
Well, they did not serve any notice, my lord. Give two proceedings.
Sir,
44 proceeding as well as big route proceeding.
we have now requested them. They will supply. They have said they will supply.
Well, 78 till date. No.
What can be done then? What can be done now?
My lord, in the year
So
1970.
we have
Within a
requested.
fortnight from date.
Yes.
Yes. You wanted the certified copies,
Yes,
you will
ma'am.
get the certified copy.
Yes, ma'am. Yes, sir. Well,
I think, subject to correction,
my lord, I
this direction.
application for certified copy.
Excellent, sir.
I file again to file application for certified copy.
No, we have requested them.
Well, only one thing, possibly going by what is recorded, possibly my learned friend's client wanted the certified copies of the proceeding for the year 1973. Appears so.
Mr. Khalid, do us a favor. Please take your learned friend outside. Please understand from him what he wants. Just give it to him.
No,
Otherwise, my lord,
that will be given. There is no.
my lord, otherwise, my lord, my total would be
They are
wasted.
saying they'll give you more.
I could not proceed, my lord.
Bilingual proceeding.
Sorry?
Bilingual proceeding. These are affidavit of substance.
Sorry, affidavit of service.
Affidavit of service recorded. Yeah, very lovely.
My lord, BLRO in his office, just like a tiger, he could not, he refused totally to serve the
Who is a tiger?
certified copy. Just like a tiger in his office.
Tiger?
Yes, my lord.
Royal Bengal?
Yes, my lord. Their conduct very bad, my lord. BLRO conduct very bad. My client, till 1970, the father died. Thereafter,
Same BLRO is not there. Same.
father died. Now their grandson is.
Same BLRO is not there. Different BLROs.
Yes, my lord.
So
Different
all
BLRO.
tigers are there.
What is your Rashi? Do you know what is your Rashi?
রাশি জিজ্ঞেস করছে আপনার
Rasi, please, Bisa Rasi.
Had it been Shingho, you could have.
My lord, their conduct very bad, my lord.
No, they'll behave well now. Acha, thank you very much.
They did not, my humble prayer only. You know,
Item 30.
Copy of the orders. Nothing.
ये appellate से appellate से कुछ oh अच्छा
Grateful to.
I'm grateful.
30 nahi, acha.
Lordship, Mr. Mukherjee, senior advocate appearing in this matter.
Milon Mukherjee?
Yes, Lordship. Kindly make it not this week, Lordship.
Not this week. Likhe now, Apurvo. On the prayer made on behalf of the petitioner, let this matter stand adjourned for the week.
Yes, sir.
অভিজিৎ চলে গেল? আছে
কৌশিক, তুমি এতক্ষণ কেন দাঁড়িয়ে থাকো একটা ডেকে? কেউ নেই দেখতে পাচ্ছ তো?
আমি তো মনে হয় এটাই আসছে 32
Yes.
with 32 and 33 34
32, I am appearing on behalf of appellant number 1.
I am
petitioner number 1.
Mr. Sinha is appearing, Lordship. Mr. Sinha is appearing, Lordship. Mr. Sinha is lodged in courtroom number 238, Lordship. And we not today, Lordship.
No, no.
33. My lord, on the last
More than
occasion,
Years, my lord, they are in custody.
28 years.
12 years, my lord. More
near
than
about
12 years.
13 years, 12 years, 3 months.
After post conviction,
Three advocates are there.
Yes, your lordship,
conviction,
convicted.
when he was convicted.
Just a minute. My lord, convicted on 11th of December 23 and 12th of December 23, respectively, by the learned additional sessions judge, 8 Court, Alipur, South 24 Parganas.
What he has committed? What is the offense?
Offense is, my lord, under section 302, my lord, kidnapping, murder, along with 364A. Now,
Ransom.
so far, kidnapping part is concerned, that person was rescued by the police authorities. He has been rescued. And the allegation was that, my lord, the driver of the so-called victim,
So we are not on the merit. I am relying upon the Southern Singh and Kashmira Singh Lordship. This honorable bench already.
In which matter?
This matter, Lordship.
No, 32, 33, 30, in which matter? 32.
33.
So who is appearing at 32?
Sir, we
32, I
are
am appearing.
serially, please don't confuse us.
Now,
We are on 32 now.
yes. Now, what fell from your lordship, my lord? The driver, the allegation was that the driver was taken into the jungle.
State is ready.
Three seats of stop, Mr. Sinha, she's on her legs.
Three seats of three seats of lawyers.
It's very difficult for us to accommodate everybody, madam. You are there, you are there.
Three seats of lawyers are there, my lord. In item number 32, 33 and 34, my lord.
Yes, 32. Please tell us.
Yes, tell us.
Yes, so that is the allegation.
What is the allegation?
My lord, allegation is that the victim who was rescued later on, my lord, was taken in a car by one person named Onkur. I am not for the Onkur. My client is Rakesh. Now, he was taken in Howrah. Thereafter, my lord, in a car, Innova. My lord, he was taken in Bihar, Jharkhand.
Greedy.
Yes. And thereafter, my lord, allegation was that some ramsack was asked from his father.
Ransom was
Now the driver was taken by some of the accused persons, and thereafter, after 10 days, my lord, he was recovered. His body was recovered. That is the allegation.
Whose body?
The driver of the car.
Driver's body.
The driver of the car.
Victim was recovered.
Victim was rescued by the police.
Police.
Yes,
So this is a commission of murder of that driver.
absolutely.
So one person was kidnapped and another person was murdered.
Yes, that is the allegation.
That is that. Now, how you have been entangled?
My lord, I have been entangled, my lord, because of the version of the PW1, the victim, his father. Now, here, surprisingly enough, my lord,
Victim was alive.
Victim is alive.
So victim deposed.
Yes.
Deposed.
Whether what he has said against
PW2.
PW2.
PW2. Why is the position?
If your lordship kindly comes to the judgment. Ankur Kumar Shaw.
Kumar Shaw.
Yes. Inner page 3. There are 19 prosecution witnesses.
Yes.
Just a minute.
PW2, my lord. Page 7, inner page 7, my lord.
Yes.
Yes.
আমরা এটা পড়ে নিতে পারি।
তালিকাটা হয়ে গেল। আরে জজ জিজ্ঞেস করলে তো বলতে হবে কি মুশকিল জিজ্ঞেস করছে আমাকে উত্তর দিতে হবে এটা আমাদের ভাইটাল পয়েন্ট
Main allegation against Tinku. No, both. I'm sorry, ma'am. Kishore Pandey.
So you were there.
Yes.
Sketch funding.
Yes.
So
Now, one subject to correction from your lordship, my lord, but from one relevant point, I must say, though I got the brief only 2 days, pointed out by my learned junior, my lord, in a criminal trial, your lordship has vast experience. This is the first time, probably subject to correction, I came to see that when the charge is of murder, 302 is there, my lord, doctor is not being examined. Though the name of the doctor transfers
postmortem report has not been exhibited.
exhibited, but there is no evidence of doctor
So have you raised any objection?
in the trial court.
Yeah, during
Yes, trial court, my lord, objection has been raised because entire, my lord, prosecution's case stands on suspicion. It has been raised.
No.
Yes.
Yes, I am.
You are representing only.
My lord,
two
I am
persons?
representing, my lord, the appellant number 1, Kishore Pandey, alias Rakesh.
Not Dilip.
No.
No, I am for Dilip.
Not Dilip, not Tinku. I am not representing. And already, my lord, I am languishing in jail for near about 13 years.
13 years, my lord.
Kindly
for that
appreciate.
reason, my lord, we are submitting, my lord. Only for that reason, my lord, we are submitting, my lord.
No, if you say we have to check every order sheet because there may be some accused absconding. There may it may so happen. Whether the prosecution was responsible for the delay, then we cannot. But so far as Saudhan Singh is concerned, there's a ruling that after 5 years after conviction.
Conspiracy.
So it is Kashmir Singh or Saudhan Singh or whatever it may be. So it is only 2 years after conviction. So
Kashmir Singh Lordship as a whole. And this honorable bench
Supreme Court, my lord,
elaborately,
You have a copy of Kashmira? Give it to.
I have Kashmir Singh as well as.
You are representing whom?
He is also representing one of the accused.
Name.
33.
Naam
You
pata hai.
know the name of your client?
Yadav.
Sukhdev Yadav.
Sultan Singh ta aage dao na. Sultan Singh ta aage dao.
Saudhan Singh.
ta aage dao. Sultan Singh ta dao.
All along in the custody.
Yes.
All along in the custody.
সামনে দাঁড়িয়ে পড়ে
Saudhan Singh, Kashmir Singh.
এটাও বলতে হবে আমার।
ঠিক আছে।
नाम है कुछ चालू
paper book is ready.
Is ready. On an earlier occasion, the state was directed to file their custody reports.
So I want to know driver of this
The victim,
PW2 was murdered. Whether they committed murder of that driver, they took away PW2,
Yes.
kidnapped.
Yes.
Thereafter, police rescued him. But at that point of time, the victim driver was not along with him.
If your
What is the
lordship
fact
takes,
of factual case,
if your
factual
lordship
aspect?
takes up the, my lord, I have the judgment, my lord, PW 2, page 7. If we read that PW page 7 onwards,
We have read. When he was taken, at that time, his driver of Innova car was not there. That's why he traveled in a taxi with the accused person.
And PW2 my lord called the driver.
But driver was murdered.
Murdered, my lord. And one thing, my lord, I have got the, my lord, paper book, my lord.
You need time.
I was not there on that day, Lordship. I am 80 years old person.
My lord,
একসময় বললে আমি শুনতে বুঝতে পারবো।
my lord, apart from that, the brother of the deceased, even in his evidence, had stated that these persons had come to their house on the earlier day. These
That is-
persons.
Whether there is a clear case that they murdered.
no, my lord, no.
I am asking her.
Subject to your lordship's correction. The appeal is only not even a year old. It's a 2024 appeal. Subject to your lordship's correction, these principles do not apply in these cases. And when the paper book is ready, my lord, the trial had extended for such a long time.
Yes.
That will not inure to their benefit at this stage. If the paper books are ready, my lord, ideally it is my humble submission, the appeal should be heard out.
What
Because
happens?
It is not a very good case.
What happens to the 2019 appeals, Ms. Sinha? Who will hear them?
Contempt 29.
No, not this one. There are 2019 appeals pending also.
My lord, in that case, my lord, based on the principles laid down by the Honorable Apex Court, the benefit may be given.
So we'll have to hear those appeals also.
True, my lord.
So how do we hear this appeal now? We have limited time. That is the whole point. If you look at Kashmira Singh, the Justice Bhagwati, was it Bhagwati?
Bhagwati.
Recorded that we are hearing appeals of 1972 now.
True.
1974 appeals, we can't touch for another 2 years. Same situation.
Lordship.
And 12 or 13 years, the other.
And my lord, one more thing.
Any ocular evidence, witness?
That, my lord, at least so far as one Tinku is concerned, my lord, his complicity is the maximum.
Tinku is not a petitioner here.
Yes,
We are only on Rakesh now. Let us take one by one. Rakesh ke the other.
Then an advocate for the petitioner has
Kishore Pandey.
Alias Rakesh.
Kishore alias Rakesh. Yes. My lord.
No, I
আরে
was
জজ
taking
সাহেব কি
on
বল দাঁড়ান না বলছে আপনি একটু ধৈর্য ধরুন একটা একটা করে দিচ্ছে
we shall hear Tinku. Okay. The learned counsel for the petitioner has submitted that petitioner Rakesh Pandey alias বললো একটা জানি না
এলাস আছে
Kishore Pandey, alias Rakesh.
এলিয়াস
is not the principal accused, and the evidence of the W2 has disclosed the same. However, the petitioner is in custody for about 13 years. He was all along the custody during trial, and in view of the judicial decisions reported in Kashmira Singh, and Saudan Singh, maybe enlarged
deeply obliged.
I am recording your submission.
Oh, I'm sorry.
Check.
No, my lord, I'm sorry, my lord.
There is no difference between the district courts and the CGM courts and high courts.
Well, sorry.
Yes,
I pray
seriously,
apology. I pray
afraid. May be enlarged on bail on any stringent condition, since there is no chance of an early hearing of the appeal. Stop. There. The learned counsel for the state opposes the prayer for bail strongly. According to him, there are sufficient evidence against the present petitioner. Stop. The petitioner is languishing in the judicial custody. Now, he's in the custody. He's in the custody for only 1 year post his conviction. So, therefore, substantiated in Consider Singh Supra, not applicable in this case. Stop. Para. We have perused we have considered the judicial decision and aforesaid. Stop. It appears that there is in custody for more than 13 years.
Near about 13 years.
About 13 years, and there is no chance of an early hearing of the case. Stop. It is also found from the record that there is an arguable case on behalf of the long incarceration of the present petitioner. They are trying to allow the prayer for bail of the present petitioner or আপনার জানেন তো
না ও জানেন না বলতে বলে বা তন্ময়
in residence of which area?
My lord, residence of my lord, village Kothra.
No, he has to remain. Where is the case? Alipur. He has to remain within the local
Preventional home, your lordship is.
No. I cannot allow him to go to BR.
No. Your lordship may pass.
He shall remain within the jurisdiction of limits of Kolkata and shall meet the IC Alipur PS once in a month. তারপর যা যা কন্ডিশনটা আছে আর সাবজেক্ট টু স্যাটিসফ্যাকশন অফ হুইচ কোর্ট
Alipur.
Same Alipur. Same Alipur. Another page Kosba. Same Alipur or Kosba. Same Alipur. SCGM Alipur. The Bengal file or Calcutta file?
My lord, Alipur.
No, not Alipur. It's a Kosba.
No, I understand, my lord. The police station.
Same oblique
Yes, it will be, my lord, in the Bengal file, I think, my lord, subject to correction.
Same, then SCGM Alipur.
SCGM Alipur.
33.
My lord, in item number 30, my lord, there is two appeals, my lord.
What they?
Appellate number 1, your lordship granted. So far, the appellate number 2.
Where is your application?
Yes, in this application, 2 appellants are there, my lord, in item number 33.
30, not 32 years.
32, my lord.
32, my lord, there are 2 applicants. One I am representing and my learned senior friend is representing.
What I asked Mr. Mithro Misena, how many applicants are there in CRAN 1? He said 1.
My lord, I'm sorry, my lord. Actually, my lord, I received the brief only day after before. My lord, 2 applicants are there, appellants. My lord, first one I am representing. Second one, my learned senior friend.
Same application?
Yes,
Same application. Same application.
2 counsel for the applicants. Never heard of it.
My lord.
No, what has happened, my lord?
Never heard of it.
That's true, my lord. But here, my lord,
Hey, ওটা তুমি
came with the
দুটো অ্যাপ্লিকেন্ট থাকবে
yes.
ক্র্যান 1 যেটা হলো এটা আরেকটা হচ্ছে দিলীপ কি সেকেন্ড অ্যাপেলেন্ট
Dilip Sharma,
দিলীপ শর্মা
appellate number 2.
Resident of?
Yes.
Resident of?
Resident of, my lord.
Here.
Tomjur.
No, Tomjur.
ওই
Tomjur, Howrah.
বেইল অ্যামাউন্টটা তাহলে 10,000 rupees each.
Tejpur, district Chapra, Bihar.
He is a permanent resident of Bihar.
Alipur. It's a very good place.
Deeply obliged.
His husband was also from Bihar.
33 lordship.
No adverse report about his conduct.
Yes.
Really.
Dilip Sharma.
33 lordship, I am appearing. on behalf of Sukhdev Yadav alias Chacha.
The resident of,
Sukhdev Yadav alias
what is
Chacha.
the was made evidence?
The other one, he is also not similar.
Same, similar.
My lord.
পর্যন্ত মুক্তিযোগ্য সমান এই একই হবে।
33 items.
Now Tinku,
এই নাম পাল্টাবে, নম্বরগুলো পাল্টাবে। করে otherwise-
you are the main culprit according to state.
Yeah.
Yes,
No, my lord, I am standing on the same footage as
you
Rakesh.
are not standing, you called everybody.
No, my lord, I am standing on the same footage as Rakesh, my lord. Same footage.
No, Tinku's name is everywhere in the evidence.
Do you have anything to say, please?
Custody
You are
my
not
lord,
standing on the
13
same
years, my
footing
lord.
according to us. Any other ground? You can
Same footing as my lord, Rakesh, my lord.
So far as period of detention is concerned, yes.
Yes, my lord.
But otherwise, so far as your role in the crime is concerned,
All the accused persons were together, my lord, at the place of occurrence.
You befriended with him with an aim.
is what do you have against him? Tell us.
My lord, if your lordship kindly comes to, my lord, the evidence of PW2, my lord. There are some additional complicity attributed to Tinku, my lord.
And then the case is ready for hearing.
My lord, so far as Sukhdev is concerned, my lord, handing over of valuable belongings. But if your lordship takes up Tinku, my lord, even earlier occasion, Tinku was the person with whom the victim was last seen. That I am taking him to a birthday party. That is PW6, page 12.
He was the friend of Unkur, my lord, the victim. He was the friend.
If your lordship sees PW8 at page 12, he's a garage owner, my lord. He arranged the rented accommodation for Tinku, that is after the incident. Tinku introduced a lady with whom he started staying in that rented accommodation. Thereafter, they left. My lord, if your lordship takes up PW9, there also, my lord, the person saw Tinku and not the other two who have been granted bail. So complicity-wise, my lord, certainly he is on a much worse footing, but detention, my lord, I cannot say. That's the same.
Lordship. Lordship, my lord, Tinku, Lordship, is the friend of Unkur. He used to go to the house of the Unkur. My lord, he is not murdered, my lord. His driver has been murdered, my lord.
Suddenly.
He is not the murderer.
It's very vital.
But if it is on merit, my lord, kindly give me a day's accommodation. If it is on,
my lord,
You want a day's accommodation? Why?
if it is on merit, my lord, kindly.
Huh? Sorry, can't hear you.
If it is on merits, my lord, kindly give me the day's accommodation.
No question of merit.
But
In a suspension, application for suspension, we'll only have see the prima facie case.
We'll hear out the appeal very soon. No problem. Yeah.
The applicant petitioner prays for suspension of sentence. Stop. He says that he stands on the same footing as Kishore Pandey alias Rakesh. That's what you said, Rakesh.
Yes, my lord.
Comma, another accused in this case, comma, who has been granted bail earlier today. Stop. He says that he is also in custody for about 13 years. Stop. He therefore prays for bail. Paragraph. Learned state advocate draws our attention to the depositions of PW6, PW8 and PW9, from which PW9 and PW11, from which prima facie the complicity of the petitioner in the alleged crime of murder is clear. Stop. It cannot be said that this petitioner stands on the same footing as Kishore Pandey alias Rakesh or Dilip ki chilo Sharma. Who was the other one? Dilip Sharma, who were granted bail earlier today. Stop. Paragraph. In view of the prima facie incriminating evidence on record against the petitioner, comma, we are not inclined to allow his prayer for suspension of sentence, comma, at this stage. Next, the crime such and such dismissed.
Lordship, we are deeply obliged.
এগুলো একটু রেখে দেন, সব একসাথে।
অনেকগুলো
Custody reporting মিলি।
রাজকুমার যাদব রাজকুমার পান্ডে ও এদিকে
Mentioning করো।
May I have,
Yes.
may I have your lordship leave to mention, my lord, the Exide matter which is running in the list, item number 24. My lord, the Exide matter, it's parted before your lordship, my lord, if your lordship kindly fixes it. My learned friend is a my learned senior.
Parted.
Yes, yes.
Which one is not?
My lord,
We'll take it up. We'll take it up serially, Mr. Ashudri. Can't be helped. Can't be helped.
only
Yes, call the rest.
only
May I, my lord, have your lordship's kind leave, my lord, to mention a matter with the leave of Justice Rai, my lord. This pertains to, my lord, that HIDCO matter, my lord, your lordship was hearing, my lord, a separate bench was required to be constituted. I understand your lordship's, my lord, pressure, But my lord, if my lord can do something about it, my lord.
Very well. You have said, we have heard. Bye for now.
Original side matter, item number 1.
I am for the appellant, my lord, who have got the possession.
Production of report. Oh. এটা তুই লিখেছিস revision decree. Okay. Very.
Two.
May please, Your Lordship. Volume 43 ka din na. Volume 43.
Mr. Mithra, you are in reply.
Yes, yes. I mean, reply, I shall deal with the decision cited. Well, so many decisions have been cited, my lord. I was, my lord, absolutely got lost in those.
Most of the judgments were cited. First court also.
This is what is called multiplicity of decisions.
Well, we tried not to cite judgments on the same point.
Only 8 judgments cited on the same point. Lordship will be pleased to take 43, volume 43. I would like to, my lord, start with placing two paragraphs, a few paragraphs from the impugned judgment before I, my lord, take your lordship into the other points. My lord, in volume 43 at page 6318, the judgment, impugned judgment starts. But page, kindly come to page 6323, paragraph 15.
How? Yes. Impugned judgment.
Yes. Memo, if your lordship looks into the memo of appeal,
তো বলছে impugned judgment. Yes.
Kindly come to internal page 6.
Yes.
I am just indicating to your lordship the paragraph which I am going to urge before your lordship. Only those points, no other point. Paragraph 15. Learned Senior Counsel next argues that the award of rupees 58 crores 50 lakhs as damages for breach of MGO clause from July 2014 is ex officio perverse and vitiated by patent illegality, being based on no evidence of any loss or damage suffered by the claimants. The award it is submitted fails to advert to the relevant materials and evidence produced by the petitioner. These are the points I have urged, which in fact established that the claimant was able to sell / allot the gas
meant for the petitioner to third parties and thus suffered no loss or damage. The award of damages is perverse, being based on no evidence whatsoever. Then 17, the tribunal proceeded on the premise of the recording in paragraph 41 of the CCI judgment, exactly the argument I have made. In a proceeding initiated by an employee or associate of the petitioner before the CCI, impugning the various clauses of the gas purchase agreement to the effect that the claimant respondent had to flare up 28.48% of the gas produced in 2015-16 as it had no market for the same in the face of the competing products. The impugned award holds that these findings of fact are affirmed by the High Court at Delhi. It is argued by the petitioner that paragraph 41 of the CCI observations did not refer to any loss or damage caused to the claimant by the alleged breach of MGO clause, but was merely a general observation. Thus, such findings were not conclusive within the contemplation of Section 61 of the Competition Act as erroneously held by the arbitral tribunal. That apart, the percentage of gas produced by the respondent being flared in 2015-16 is not relevant, nor does it establish that the claimant was not able to supply the contracted quantity of gas to the other parties after termination, which is the determinative test for considering whether the termination has resulted in any loss or damage to the claimant. Since the seller respondent, even after termination of the contract, was able to sell the contracted goods to third parties, there could not have been any loss or damage suffered by them. This is our submission. Then 21. The award relies on the judgment of Delhi High Court dated 10th October 2019, which itself holds that the quantity of gas which was earlier supplied by the claimant to SRMB was after termination of the contract being supplied to the claimant by the claimant to other purchasers. The Delhi High Court records that it is nobody's case that the gas could not be supplied to other consumers. And these facts and the fact that the quantity of gas which was earlier supplied to SRMB after termination of the contract being supplied to other purchasers does not in any manner render 5.2a of the agreement unfair or discriminatory. Thus, the award is also perverse on such count, being contrary to the findings of the Delhi High Court. The documents produced by the petitioner which show that the flaring of gas decreased after the termination of the contract was not considered by the tribunal. This is another point. Further, it is argued by the petitioner SRMB that the tribunal declined to refer to the material evidence on such count on the premises that SRMB had neither referred nor disclosed those materials. However, the statement of defense of the petitioner denied the averments in the SOC that any loss or damage has been suffered in respect of the MGO or any amount was payable as quantified at the MGO from 2014 to 2034. The aforesaid pleadings in SOD enabled the petitioner SRMB to produce evidence in the form of the returns filed by the claimant before the Directorate General of Hydrocarbon to show that no loss or damage had been suffered by the claimant post termination of the agreement in July 2014. And our submission had been that these documents, having been on record, should have been taken note of by the arbitrator. Then the next paragraph is also important. The tribunal completely ignored the evidence adduced by the petitioner, particularly the reports authored by Chrysil and Care, being credit ratings agencies engaged by the claimant to show that the claimant's customers and business had improved considerably post determination of the contract. So, my lord, these points were all urged. It is not that these points were not urged. These points were urged. The learned judge took note of them, recorded it in the judgment, and had dealt with them, my lord. I am questioning the way it has been dealt with. My lord, kindly come to para 80 at page 20, internal page, my lord, 24. I should say, my lord, kindly come to para 82. The Delhi High Court, in a somewhat different context, held that it was nobody's case that the gas could not be supplied to other consumers. In such backdrop, it was observed that it was not the case of SRMB that if customers are available requiring gas at a particular point of time, gas available to the claimant would not be supplied to them. The NGO liability, it was held, was only to mitigate the risks in committing a long-term supply, and that the fact that the quantity of gas which was earlier supplied was after termination of the contract being supplied to other purchasers does not in any manner render clause 5.2 of the agreement unfair or discriminatory. Well, nobody is questioning. Well, will submit to your lordship that after the award has said that these clauses with regard to MGO and all that, and my lord, the penal consequences for non-compliance with that, they are, my lord, valid. There is no question of questioning that anymore. And it was not questioned. But, my lord, it seemed, my lord, the emphasis was put on something different. What was said is this: our submission had been in the trial court this, that look, this gas which was to be given to us after termination, they have been sold to X, Y, and Z. Therefore, the court will have to consider as to what is the quantum of damage. It is the assessment of the quantity of damage that has been suffered that has to be considered by the court. And on the basis of that submission, I relied upon these evidence, not for the purpose of, my lord, any more castigating or, my lord, condemning the clause itself. In fact, my lord, I could not have questioned that. Then, my lord, next paragraph. Hence, it was not a conclusive finding, nor was the court so-called the court so called upon to decide on merits of the issue as to whether gas earlier supplied to SRMB was being supplied to others. Well, my respectful submission is the learned judge had completely, my lord, misunderstood our submission. The premise of paragraph 53 of the Delhi High Court judgment was merely that it was nobody's case that the gas could not be supplied to others. And even if there was such supply after termination of the contract, it does not render clause 5.2 unfair or discriminatory. Well, I don't know, my lord, why this particular issue has been gone into. This was not the purpose of our making this submission. My lord, the Delhi High Court, in fact, my lord, CCI and Delhi High Court was concerned with the validity, legality, validity, and fairness or justification of MGO clause. And that was conclusive. The arbitrator was bound by it. The court is bound by it. We did not question that. The fairness or unfairness of the clause was not in question before the issue. Then, my lord, kindly see this. The said observation cannot be blown out of proportion, but has to be read in the context. Rather, it was the categorical finding of CCI order, which was affirmed by the Delhi High Court on merit, that there was 28.48% of flare-up gas produced subsequent to termination of the contract, which was a specific and precisely enumerated value of such flare-up. So again, my lord, I submit to your lordship, the learned judge also was, my lord, misled into believing that 28.48% flaring of a gas was a finding of either CCI or of the Delhi High Court. Again, my lord, the perversity has come in here. Even otherwise, if we proceed on the basis of crisis report and care report, as well as documents filed by SRMB, which if assumed to go on to show that there was almost equivalent flare up of gas even after termination of the contract as there was before, the same does not help SRMB in any manner. This is wrong. I say, my lord, that once it can be shown that a portion of the gas has been sold to third parties, the issue of mitigation comes into the picture. Immediately, Section 73 comes into the picture. One cannot ignore our provisions of the law. And this has been ignored in my respectful submission here. Then the next paragraph, the premise of the MGO clause is not an actual location of loss suffered by the supplier. It is a prevalent practice in such long-term contracts for supply of energy by way of electricity, gas, etc., to introduce a minimum consumption clause, which is in the nature of an assurance to the supplier that the huge investment in grid and other infrastructure for supply of consumers, which is undertaken by such supplier, is justified by the long-term supply. Premature termination would only entail loss of the minimum guaranteed amount, which is the MGO value of the present case, but also may be detrimental to the maintenance of the supply grid itself. Now, my lord, I pause here for a moment. I shall show to your lordship when I deal with the judgment cited by them, the Supreme Court judgment in the Bihar electricity case. The court said, if I may just refer your lordship, my lord, I shall come to this particular judgment when I deal with it. My lord, here, the court has made this observation as to why it is so. It's said that installation by the license, sorry. It said that installation by the licensee involves certain capital amount of capital expenditure in plant and mains on which he was to have a reasonable return. And that is why, and this is the justification for having the MGO clause. At another place, it has been said that the installation has to be continued irrespective of whether energy is consumed or not. And this is the reason. MGO clause is really to provide for a fair return on the outlay of the licensee. Therefore, MGO clause is that because you are maintaining the establishment, you are maintaining the staff, the grid is being maintained, you have set up an establishment for the purpose of compensating for that. MGO is, my lord, MGO clause has been inserted so as to recover this amount of money. Then the natural question arises, supposing if that is so, then the justification of MGO clause is the existence of that plant and machinery. If, my lord, it is shown that the plant and machinery had been dismantled, a direction has been given that you dismantle this particular thing. So, my lord, plant and machinery or capital expenditure no longer is there. Then why should, my lord, the MGO clause will continue? This is a very pertinent question, my lord, it comes up. If this is the purpose of it, then the capital expenditure, if it no longer is sufferable, then why should MGO clause be taken recourse to for the purpose of, my lord, recovering the amount for that? In this particular case, the award says you dismantle it, and at the same time says you continue for up to 2034. I say this is the perversity. You are not considering the concept of damage. You are not considering the concept of mitigation. Mitigation in two ways. Number one, mitigation is by way of the gas being sold is not to X, to Y, Z, etc. You should take note of that for the purpose of reducing the amount of damage, if any. If it is found that more gas had been sold, then you didn't suffer any damage, and therefore you are not entitled to it. The judgment of the appeal court, Court of Appeal, my lord, of the two appeal court judgment, my lord, I cited on the last occasion. Secondly, my lord, if the MGO clause is for the purpose of, and the language I am quoting from, my lord, 1991 Supreme Court cases cited by them, installation by licensee involves certain capital amount. So if installation is not there anymore, if by an order of court, by the award itself, the installation is dismantled, then can, my lord, one say that for the purpose of continuing an installation which is not continued, you are to recompense this by way of payment of damage? So this is the second perversity in the award itself. My lord, kindly come back to page 26, para 86. Also, it is irrelevant. I say, my lord, this is wrong. It is irrelevant whether the same amount of gas as consumed by SRMB was flared up even after termination of the contract with SRMB. As long as there is even a small amount of flare up, it would indicate that at least some of the gas produced by the supplier is not used up. Mitigation of damage is completely thrown out of the window. Then what we are talking about in my lord, in the Indian Contract Act, my lord, your lordship will be pleased to point out in section 73, my lord, the explanation. In estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. This is, my lord, our statutory law. It no longer is in the realm of, my lord, the judgment law. This is a part of our statute. And my lord, my respectful submission is this, that when one is considering the amount of damage that is suffered, one has to, my lord, follow the language of section 73. Compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. This, my lord, I respectfully submit to your lordship, and this is what, if I may respectfully submit to your lordship, this is what, my lord, has been said in that judgment. Your lordship, kindly just allow me in this connection to just point out to your lordship that paragraph in Charter and Sullivan. My lord, that judgment which I placed, my lord, cited before your lordship on the last occasion. It says at page 535. Which one? My lord, this is Charter and Sullivan reported in 1957 weekly law reports. 1957, 2 weekly law reports. Page 528. I just only want to place this paragraph, which summarizes, my lord, the law. Lordship, your lordship has got it, my lord. Kindly come to page 535. The penultimate paragraph on that page. The matter therefore stands thus. We filed it down. It says, my lord, the matter therefore stands now. Stands thus. Sorry. Yes, please. Page 535. 535, my lord. Last but 2 paragraphs, I should say. Before, my lord, Mr. Upjohn's judgment cited by my learned friend has been referred. Before that, my lord, 2 paragraphs before that. The matter therefore stands thus. If the defendant had duly performed his bargain, the plaintiff would have made on that transaction a profit of £97 15 shillings. The calculation accordingly starts with a loss of profit through the defendant's default of £97 15 shillings. That loss was not cancelled or reduced by sale of the same car to Wijli, for if the defendant had duly taken and paid for the car he agreed to buy, the plaintiff could have sold another car to Wijli, in which case there would have been 2 sales and 2 profits. See so and so, particularly of Mrs. Hamilton and Buckley. Then the plaintiff must further, the But the matter does not rest there. The plaintiff must further show that the sum representing the profit he would have made if the defendant had performed his contract has in fact been lost. Here I think he fails. In view of Winter's evidence to the effect that the plaintiff could sell all the human beings' cars he could get. So, my lord, the fact that loss of profit would be there at 97.15 shillings is not, that's not the end of the matter. The plaintiff must further show that this loss continued to be suffered, because if it had been shown that the car had been sold at a price at more than £100, then my lord, this 97.15 shillings wouldn't have been there. And this is quoted, the plaintiff must further show, and this is where, my lord, the Mrs. Abjohn's judgment has been criticized. This your lordship will be pleased to find there. Then your lordship will kindly come to page 537. Lordship will kindly come to the last paragraph before Lord Justice Hodgson's judgment. But it was for the plaintiff to prove that he did in fact sustain the loss of profit claim. And this, to my mind, he wholly failed to do. The mere assertion by Winter, we have lost sale of a car, is clearly not enough, particularly when read in conjunction with his, then quote, can sell all the human beings we can get. Accordingly, there was, in my view, no evidence on which the judge could properly hold that the plaintiff had suffered the damage claimed. So one has to lead this evidence to show that he has suffered damage. Only because I am saying that you have default. The default is admitted. I am not going to question that, as I told your lordship. The breach is admitted. Quantification of damage is the point. In order to quantify the damage, the plaintiff will have to lead some evidence. This evidence, if it is absent, then, my lord, the plaintiff failed to prove his case. There was no evidence on which the judge could properly hold that the plaintiff had suffered the damage claim, and I would allow the appeal. Well, this only one other thing. Well, these judgments, my lord, are quite, my lord, eye-opener in the sense, my lord, the way they are explained. Lordship will kindly come to page 540. Page 540, second paragraph. The matter cannot, of course, be worked out ad infinitum, but would be decided on the probabilities of the case and having regard to the nature, extent, and circumstance of the dealer's trading. If a dealer has 20 cars available for sale and 25 potential buyers, he still would make his full profit if he sold the 20 cars, notwithstanding that the 2 or 3 purchasers had defaulted. So if I have got 30 purchasers and 2 defaulters have defaulted, and I can sell these 2 defaulted cars to 2 other persons at a higher price, then I make a profit. I don't suffer any loss. This, my lord, owners, the plaintiff will have to discharge. He cannot say that 20%, 15%, 10% of the profit I could have earned if my lord, this contract would have continued till 2034. This is, my lord, I am questioning in this. So, my lord, kindly come to this particular concept has been totally, I should say, ignored by the learned judge. Kindly come to page 26, last portion of the paragraph. I should say, my lord, about 5 lines from the from the top of para 86.
It is not a relevant.
Yeah, we can take it. 5 lines from the top. It is not a relevant question whether the gas earmarked for the consumer, SRMB, was being supplied to some other consumer, since supply to one consumer is not mutually exclusive with the supply to some other. It may very well be that the supplier enhances its infrastructure and/or on the basis of the same infrastructure caters to more consumers, thereby increasing the earnings. Even if SRMB was continued to be supplied with gas, it was open for the claimant supplier to increase its supply and/or to maintain the previous supply and go on supplying gas from its network grid to other new consumers, which would fetch more profits to the supplier. There was no exclusivity clause in the agreement between the parties restricting supply only to SRMB. Hence, even if the claimant went on supplying to other over and above the quantity supplied to SRMB, it would have earned more profit, to which there is no bar. But here, I respectfully submit to your lordship, this concept of mitigation of damage, which was the basis of the argument, my lord, that has been ignored. Thus, as long as there is even a wee bit of flare-up of gases, there is wastage of gas produced by the supplier. And consequently, there cannot be any dilution of the MGA clause suffered by the supplier. My lord, what has been, I feel, my lord, what has been confused here is with regard to the operation of the MGO clause and the damage suffered. The concept of damage suffered upon a breach, upon a termination of the contract, is a concept which is, in my respectful submission, separate from, because well, the moment there is a breach of contract, one has to look into the effect of or the consequence of non-performance by the offending party. Now, if it is found by reason of the non-performance by the offending party, the non-offending party is not suffering any damage because there is open market for them and it is being sold, then immediately the question arises that to what extent the damage has been suffered. One cannot just look into the 34 up to 2034 it would have been supplied, therefore 15% of it, 10% of it, and therefore you put it like that. That will not do. Then, my lord, that concept of mitigation of damage is totally nullified. One has to look into the issue as to whether by not supplying to me, this gas which could have been supplied to me had been supplied to somebody else at a higher price, at a lower price. The issue of damage immediately comes in, and the onus is put upon the plaintiff or the claimant to lead that evidence. This was absent here. Yes, paragraph 87. Thus, as long as there is even a wee bit of flare of gases, there is wastage of gas produced by the supplier, and consequently, there cannot be any dilution of MGO loss suffered by the supplier. I am not questioning this. I am saying yes, by reason of the fact that there had been a flare-up of gases, even wee bit, some damage has been suffered. You quantify that damage. If the flaring of a gas is 100%, there will be one kind of damage. If it is 50%, there will be another kind of damage. If it is 25%, there will be, and if there is no flaring up, there will be no damage. This concept, my lord, I feel, my lord, had not percolated into the judgment. Even then, as long as the entire amount of the produced gas was not exhausted, the supplier would continue to suffer loss due to a termination of the contract. Yes, let me concede for the sake of argument that is so. Question is how much for the particular amount of gas which was to be supplied to SRMB. Therefore, my lord, that particular amount of gas which was supplied to be SRMB Had it, if it had been supplied to X, Y, and Z because SRMB failed to take it, then my lord, should that not be taken into account for the purpose of assessment of damage? It is not that the gas earmarked for SRMB is being supplied to others. It's not a question of earmark. Gas is not something like electricity. It is not something which is earmarked for anybody. It is available, it will be supplied to the consumers. Consumer X, consumer Y, consumer Z. If X doesn't take, Y and Z will take. To the extent Y and Z is taking the quantum of gas which could have been supplied to X, to that extent the damage is lessened. The claimant is a producer of gas and can very well supply to many other consumers than SRMB. Of course, that is correct. And therefore, my lord, the conclusion which is at paragraph 88 is wrong. Kindly see the basis is what is contained, my lord, in the earlier paragraphs. And the final paragraph, hence, the argument of SRMB linking the quantum of post-termination flare-up of gases to the absence of loss is irrational and not acceptable. Even if the flare-up remained the same, the supplier suffers loss to the extent of the MGO amount. This is why. Where does it get? The supplier suffers loss to the extent of MGO amount as long as there is flare-up of them. No, no. This amount, the MGO amount clause, the MGO clause, in my very respectful submission, supposing, my lord, the gas which was sold to the third parties, it is found that it is sold at a lesser price or lesser quantum of gas, then the damage will be more. If it is more quantity of gas sold to them, then, my lord, damage will be less. So this concept, my lord, had not percolated into this. Now, keeping this in mind, I will respectfully, my lord, request your lordship to look into the judgment cited.
Before you take up those decisions, I can't resist myself, can't help observing that in more than one sense, gas can be troublesome.
Yes, sir. Gas always causes problem, depending upon the quantum. Indigestion, whichever side is the issue. Kindly take the decision cited by my learned friends, Bihar State Electricity Board. This is the foundation of the award, foundation of the judgment of the learned trial judge, and this should be so. But let us see what it says. This is in the volume of judgment cited by my learned friends, item number 15, 15. আপনাদের কি একটাই ভলিউম না দুটো?
Item number 15.
Item number 15 ওটা ফার্স্ট ভলিউমেই থাকবে আর
259.
হ্যাঁ
Page number 259.
264 আমার ইয়েতে 264 This is in respect of electricity. Judgment starts at page 266. I request your lordship to come to 266, para 2. I place this is just by way of introduction. Then I shall take your lordship into the main body of the judgment. The appellant Bihar State Electricity Board, Patna.
146
কি করে 146 হলো?
স্যার একটা আপনি পুরো ওয়ান পেজ এটা আমরা ফার্স্ট দিন অ্যাপেলেট কোড ট্রায়াল কোর্টের এটা দিয়েছিলাম না কম্পিটিশনটা সেখানে
146
146 ওকে তাহলে আমার সঙ্গে পাতা মিলবে না
ইন্টারনাল পেজ
You can refer to the internal page of the judgment, Bihar State.
Yes, I shall refer to the paragraph. Kindly come to paragraph 2. Justice Saikia's judgment. তোমরা কি এই দুটো ভলিউম
কারণ ওই ফার্স্ট ভলিউমটা তখন ছিল না ডিভিশন
সেই জন্য কিন্তু আমার কাছে এই দুটো ভলিউম
ট্রায়াল কোর্টের ভলিউমটা তৈরি
না
ভলিউম 1 ওটাই এটা ওদের
এটা নয় না না ওটা নোট তো আর্গুমেন্ট ওটা না
দিয়েছে It may be item 7 there, my lord. We kindly have a look on item 7, page 146.
এটা মিলছে না একদম
My lord, item 7 in the index, my lord. Yes, my lord. 8 is Odisha state. Lord, may I just have a look at, I'm so sorry, may I just borrow one of Lord's? Just I'm. This is the one. Yes. Yes, page is same, my lord, 146.
In for future. That is the legal of guilty. They are not dissected. Damage this or injure. এটা বললেন সব জাজমেন্ট যে এনজিও ক্লজের এনফোর্সমেন্টে যে ক্লেমটা
আমি সেগুলো এক্স্যাক্টলি তাই
হি হ্যাজ গট দ্যাট ক্লেম তো আলাদা করে দিই
না না তো ড্যামেজের উপরে নাথিং টু ডু উইথ ড্যামেজ
ও তো দুবার
Correct. Page numbers are the same, 146.
But kindly come to paragraph 2. The appellant's Bihar State Electricity Board partner, hereinafter referred to as the board, entered into an agreement with the respondent, Green Rubber, a partnership firm, etc., for supplying electricity 60 kVA, and on April 13, 1981, gave electricity connection. The firm later applied that it may be given 45 kVA instead of 60 kVA, and it deposited the requisite sum of rupees 2,700. And a fresh agreement was executed on 2nd May. On 29 May 1981, the firm was given fresh connection of 45 kVA. According to the firm, it requested the board on 19 June 1981 to cut off the connections. The firm received the bills for the minimum guaranteed charge for the months of June, July, August, and September 1981, though, according to it, no electricity was consumed by it during that period. According to the board, on failure to pay the bills, the supply was disconnected on September 28, 1981. The firm ultimately received a demand notice in October 1981, kindly note this, for the minimum guaranteed charge for June 1981 to August 1981. To June to August. So during the period of the subsistence of the contract, during which period, they did not take electricity, only for that period. And that was 22,000 so and so. The firm having not paid the amount, the board sent a requisition to certificate officer who sent a notice to the firm rejecting the contention of the firm that it was not liable to pay, the certificate officer proceeded to pass an order for attachment of the firm's property, wherefrom the firm filed a writ petition of Article 226 to 27. Before the High Court, the board contended the firm was liable to pay minimum guaranteed charges in terms of the agreement, the disconnection itself having been made in terms thereof. So that was the issue. So during this period, note the period, June 81 to August 1981. And my lord, the connection was cut off in the month of September 1981. Now, my lord, kindly come to para 7. The question to be decided is whether, despite the fact that the supply line was disconnected on September 28, 1981, the firm was still liable to pay the minimum guarantee charges under the agreement. The answer depends on the agreement itself and the relevant provisions of law. Kindly note this is very important. Then the clause 4 has been quoted. Then, my lord, it is almost similar to our MGO clause. Then the Supreme Court is saying, from a perusal of the above clause, it would be clear that the minimum guaranteed charges would be payable by the consumer irrespective of whether energy to that extent has been consumed or not. Indeed, there would be no need for such provision of if the charges were to depend only on the energy actually consumed. Understood? Then, my lord, kindly come to I am not troubling your lordship, the factual part of it. Paragraph 11. No, Dorkan.
17.
Yes, 17 is the paragraph. This is where I was on. Well, let kindly come to 17. It is seen that the rule of charging minimum guaranteed charges has been in vogue since long. In London Electric Supply Corporation, the agreement between the appellant company and the consumer shall have option, etc. Kindly come to after this factual statement. During the period from midsummer to Michaelmas of 1900, the defendant did not use any electricity supplied by the plaintiff. And the question was whether, under the agreement, the defendant was bound to pay the minimum payment provided by Clause 7, even though the fact he used none of the plaintiff's electricity during this quarter. So, my lord, what the question was whether under the agreement defendant was bound to pay the minimum payment provided for clause 7, even though in fact he had used none of the plaintiff's electricity during the quarter. The Lord Chief Justice, in giving judgment, said it was sufficiently clear that the installation was put in on the terms that the customer should have the right to purchase the installation after 5 years. And during that 5 years, the customer should be liable to pay minimum rent, whether the current was de facto used or not. The minimum rent had no reference to the amount of current used, and it was therefore clear that the mere fact that the defendant had not taken any current or a small current did not affect the case. Then, my lord, this is very important judgment, and my lord, Calcutta judgment, Shoilobala versus Darjeeling municipality. It was held by the learned single judge that the minimum charge was not really a charge which had for its basis the consumption of electric energy. It was really based on the principle that every consumer's installation involved the licensee in certain amount of capital expenditure in plant and mains, on which he was to have a reasonable return. He could get a return when the energy was actually consumed in the shape of payments of energy consumed. When no such energy was consumed by the consumer, or a very small amount was consumed in a longer period, the licensee was allowed to charge minimum charges by his license. But those minimum charges were really interest on the capital outlay incurred for the particular consumer. So, my lord, kindly see this amount of MGO is intricately connected and directly linked with the concept of the capital expenditure in this. If I may put it the other way around, since there was the capital expenditure, therefore the MGO clause has been inserted for the purpose of recovering of the amount. So if there would be no capital expenditure involved, then my lord, can one say that still in pursuance of the MGO clause you are entitled to claim damage? On the basis of the MGO clause you are entitled to claim damage. I am yes. Well, in our case, what happened is this. This is a question, my lord. I have been, my lord. This has been. I have been considering in my own mind that the award says that you pay damage on the basis of the MGO clause up to 2034. The percentage of profit on the basis of the MGO clause. What is the total amount? But at the same time, in the award itself, you are directing you dismantle everything within a certain period. Now, if you dismantle the thing, then you don't incur any capital expenditure. Then why should you suffer damage by reason of that? And the award says that you dismantle this.
Capital expenditure has already been incurred. It's sunk there.
Because it has already been what has been already incurred. For that the MGO clause is there, no doubt about it. But the point is this: does one not have to lead evidence for the purpose of showing that this is the damage suffered? There is no evidence at all from the claimant side with regard to what is the capital expenditure incurred, what is the recurring expenses that are being incurred, whether the gas which was burnt out was big enough. I mean, it was big enough to so to say to compel the respondent to pay damage on the basis of that. These are all issues, my lord. There has to be something. This is what this appeal court decision say. There must be some evidence from the plaintiff to show that he has suffered damage. There cannot be a conceptual damage that up to 2034, what damage you would have suffered, particularly when if you set up a completely different, completely new setup, supplying the gas to 50 other persons. Otherwise, you completely dismantle this. Would you not bring on record before the arbitrator to show that to what extent you have incurred expenses, to what extent you have suffered damage? Then, my lord, it says that really it is the interest and capital outlay incurred on the particular consumer. Then, my lord, the case of this Madras case is there. MG Natesa Chettiar, with the provision of the minimum guarantee was just stipulation by your penalty or predetermined damage. This issue is not before your lordship, whether it's penalty or predetermined damage, because that has been determined already by two other my lord, authorities for breach on the part of the consumer to be held. It was held that in view of the minimum fixed was only consideration for keeping the energy available to the consumer at his end. It was not a penalty for not consuming the a stated quantity of energy, but was a concession shown up to the amount fixed. Then, my lord, is very important, my lord, see section 48 of the Supply Act. This is not present in our case. Kindly see section 48 of the Electricity Supply Act 1948. Section 22 deals with the obligation on licensee to supply energy. The proviso to the section says, no person shall be entitled to demand or to continue to receive from a licensee a supply of energy for any premises having separate supply unless he has agreed with the licensee to pay him the minimum annual amount as will give him a reasonable return on the capital expenditure and will cover other standing charges incurred by him in order to meet the possible maximum demand for those premises. The sum payable to be determined in case of difference or disputes by arbitration. Section 48 of the supply empowers the licensee to carry out arrangement under that act. Then, my lord, the next judgment which has been recorded here is, my lord, Wilkins Mayor Company. It was observed that the whole scheme of the act seems to show that the provision made in any contract for minimum charge was really to provide for a fair return on the outlay of the licensee. And it was for this reason that the law allowed the contract of this kind to be entered into. Then clause 11A of the schedule to the act, as it then stood, provided a licensee may charge a consumer a minimum charge of energy for such amount and determine in such manner as may be specified by his license. And such minimum charge shall be payable notwithstanding that no energy has been used by the consumer during the period for which the minimum charge is made. My lord, this is really a statutory, this MGO clause regarding electricity, my lord, is a statutory provision. On the basis of the statute, my lord, these have been, and that has been recorded here. Then, my lord, this continues that the minimum consumption guarantee charge imposed in the new tariff schedule under Section 49 of the Supply Act. This is in connection with, my lord, the other judgment of Bhagwan Industries versus Lucknow. This is, and then, my lord, the Andhra Pradesh Electricity Board. These are all statutory provision in pursuance of which, my lord, MGO clauses are inserted in this contract. And my lord, kindly note this also for practical point of view. Supply of electricity is not confined to one person. My lord, for the purpose of supply of electricity to my house, no particular special line is there. The line goes to different persons. The electricity is supplied to all. Source is the same, coming from this. What is being said here is that in pursuance of these clauses, in pursuance of this statutory provision, the clauses are inserted in the agreements with individual consumers, saying that you pay this amount of money. And statutorily, one becomes liable to pay this MGO clause in pursuance of the MGO clauses. And this has been recorded, my lord. Kindly come to, unfortunately, there is no placitum at that time mentioned. Paragraph 23, on that page 740, bottom lines, a few lines. It says, considered by the test of reasonableness, it cannot be said to be unreasonable inasmuch as the supply of electricity to a consumer involves incurring of overhead installation expenses by the board, which do not vary with the quantity of electricity consumed. This is the point. And installation has to be continued irrespective of whether the energy is consumed or not until the agreement comes to an end. Every contract is to be considered with reference to its object and the whole of its terms, and accordingly the whole context must be considered in endeavoring to collect the intention of the parties, even though the immediate object of inquiry is the meaning of an isolated clause. Then, my lord, this is with regard to the ultra vires, whether the clause is ultra vires or not on that issue. My lord, insofar as I submitted to your lordship, so far as we are concerned, we have been precluded from questioning the justifiability of the clause. The clause is binding upon us. My submission wholly is what is the effect of the clause. And these judgments, Bihar State Electricity and then the next judgment which has been cited, my lord, the judgment of Odisha State Electricity, to the same effect. The judgment of Mr. Jivan Reddy and Mr. Venkatachala, 1993, supplemented 3 Supreme Court cases. It just relied upon, my lord, Bihar State Electricity Board decision and said the reason for such stipulation and its justifiability are duly and fully explained by this court in the aforesaid decision. It is not necessary for us to refer to it. It really does not say anything excepting rely upon. Well, I submit to your lordship that we are not really questioning the justifiability of the clause anymore. We cannot do so, and I am not doing so. I am only saying that look at the effect of this clause and find out as to whether they are entitled to claim damage up to 2034 on the basis of a percentage which has been fixed by the court, just like that, without there being any evidence being led by my lord, the claimant. My lord, these are the judgments of the Indian courts. The other judgments which have been cited of the foreign courts, my lord, your lordship will be pleased to note the Port of Tilbury, Universal Resources was Panhandle, then my lord, Prenalta Corporation, and then my lord, only one Lahore case, Orient Power Company versus Sulnadar. These are all judgments. I am in one sentence, my lord, I am dealing with these judgments. These are all judgments justifying this clause, MGO clause. Therefore, my lord, that is, in my very respectful submission, with the greatest of deference to my learned friend, I submit to your lordship that is not the subject matter of any controversy anymore before lordship. That could have been some kind of a matter of the list before my lord, the CCI and the Delhi High Court. It no longer is. So, my lord, I deal with them by saying that here, my lord, the clause is said that take or pay clause, which is similar to, my lord, this MGO clause. They have been upheld by these decisions. Polymers case, and but one thing I found, my lord, in all these judgments, all 3-4 judgments, foreign judgments, your lordship will please to look into it. These judgments, my lord, all are in respect of the period during which subsistence of the agreement, the period the claim was made, during the period when, my lord, the supply was not taken. There was no claim for damage for breach of contract. What happened after the termination of it? Kindly take any one of them. I am just indicating to your lordship. This is due to the subsistence of the contract, non-payment of the amount when the contract is on during a period when the MGO clause was operative and the amount was not paid. Your lordship, kindly come to the judgment. Your lordship takes them alert. Polymers with the Emeries. I don't know where it is. In my case, it is to page 278. 2008 EWHC. Oh, 160. MJ in this one, yes, sir. MJ polymers, right, page 160. 10. Your lordship has got it. Well, this is a single bench judgment of the Queen's Bench Division, Commercial Court. Here, your lordship kindly takes the head note. The claimant had been supplying dispersant, chemicals, used in the breakdown of clay and other materials to the defendant since 1991. Article 5 of the most recent supply agreement provided, kindly note, during the term of this agreement, the buyer will order the following minimum quantities of product. 5.5, take or pay. The buyer collectively will pay for the minimum quantities of product as quantities during the relevant monthly period, the take or pay clause. The defendant purported to terminate the supply contract in May 2006 by a notice. The claimant treated the notice as an unlawful repudiation of the contract, similar to our case, which it accepted. It then commenced proceedings against the defendant. It became common ground that the defendant had committed repudiatory breach, which had been accepted by the claimant. The remaining issues included, inter alia, whether the sums due to be paid by the defendant to the claimant in respect of the Article 5 commitments for the period prior to the repudiatory breach were recoverable in debt by way of damage. The defendant submitted, inter alia, that the claim pursuant to the take or pay clause amounted to a penalty and that the claimant had to be limited to a claim for breach of the defendant's obligation under 5.3 to order specific minimum quantities. The claimant contended, inter alia, that the action was in debt for the price, and therefore the law to the penalties did not arise. Then my lord held that 5.5 is not a penalty clause. Then kindly my lord note this, if I may just place this, as a matter of principle, the rule against penalties might apply to take or pay clause. It was, however, not the ordinary candidate for such a rule, such as, for example, where a sum was specified that was found not to be genuine pre-estimate of damage, or a sum was stipulated in terrorem on the offending party. My lord, this is similar to, my lord, Delhi High Court judgment and the CCI judgment. A clause would not be struck down as penalty where there was no oppression. And this is exactly what was held by CCI. And where the clause was commercially justifiable, provided always the dominant purpose was not to deter the other party from breach. The courts would not be astute to decry a penalty clause and were predisposed to uphold the contractual terms fixing the level of damages for the breach. Then, my lord, the last line in that page, after saying that take or pay clause is commercially justifiable, on the evidence, the negotiations had taken place between the extremely well qualified, able, and savvy commercial men against a very significant commercial background, including a background of previous dealings. It followed that the take or pay clause at the instant case did not offend against the rule against penalties, and the claimant was entitled to. This is similar to my lord Delhi High Court judgment, similar to my lord CCI judgment, and therefore, my lord, this is really not on the subject on which I have addressed your lordship. Take or pay clause has been set out in at page 895. My lord, kindly come to page paragraph 5 or paragraph 6. Sorry. Placitum E at page 896. In the circumstances which I shall explain, there are now only 3 issues for me to resolve this judgment. One is whether so and so dispersal, I am not troubling your lordship. 2, kindly come to 2. Whether the sums due to be paid by the defendant to the claimant in respect of the period prior to what is now accepted to have been the repudiatory breach by the defendant in May 2006 are recoverable in debt in respect of the price of the minimum quantities of dispersion pursuant to the take or pay clause set out at clause 4 above, or by way of damages. So it says that the damage was, in this case, during the subsistence of the contract before it was terminated, the amount of damage that is to be suffered has been quantified, had been stated in the agreement itself. So, my lord, it is only prior to what is now accepted to have been the repudiatory breach. It is not, my lord, after conclusion, my lord, subsequent period. And this is, my lord, came by way of, and here this judgment was delivered in favor of the plaintiff, holding that this is not a penal clause, and therefore the concept of penalty does not apply. And it was held to be commercially justifiable. Kindly come to paragraph 46 at page 913. This is what was decided, my lord. I am not questioning this. Why these were cited, I don't know. Kindly come to paragraph 46. On the facts of this case, I am entirely satisfied that the take or pay clause was commercially justifiable, did not amount to operation, was negotiated and freely entered into between the parties of comparable bargaining power, and did not have the predominant purpose of deterring a breach of contract, nor amounts to a provision in terrorism. The evidence was wholly clear. The negotiations took place between extremely well qualified, able, and savvy commercial men against a very significant commercial background, including a background of previous dealings. At the time when they were negotiating, there was, on the one hand, an extreme scarcity of acrylic acid, a willingness on the part of the claimant to commit supply to the defendant, notwithstanding the requirement of their other customers, but in return, expecting an absolute commitment to take minimum quantity of product to be manufactured with that acid. And on the other hand, a clear recognition of the difficult commercial position in which the defendant found itself, a desperate need to secure supplies of the product, and a desire to keep the contract as short as possible, with the result that there was give and take on both sides, a shorter term than the claimant desired and a longer one than the defendant desired. But so far as the defendant was concerned, the significant advantage, as it now saw, is a get-out clause via meet or release provision in Article 5.6. I could not find Article 5.6. There was a get-out clause in this. My lord, what was held here is that there's a give and take, mutuality in contract, and parties have agreed, and therefore there was no, it can't be considered to be a penalty clause. Similar is, my lord, Port of Tilbury. And there also, my lord, this the claim that was made in this, my lord, it was during that period. It was not by way of damage subsequently. There also, the court said, and I think this is the one in which, my lord, it was by way of summary judgment, it was delivered, and it was held that the minimum quantity that was to be taken, that had been invoiced, and if you had not paid it, then by way of a summary judgment, yes, my lord, this is what, my lord, the judgment is. The next judgment is Penalty Corporation. Here also the same thing. The prime consideration was as to whether this particular clause is a clause which is a penal clause or not. And there, my lord, the court considered the various provisions of this contract and said that it is not so. In doing so, your lordship will please to come to one paragraph, Penalty Corporation. I don't know which page, my lord, my learned friend has got in mind. It is 201. This is, my lord, United States Court of Appeals judgment dated 4th September 1991. Your lordship has got that? Kindly see overview in the front first page. Several gas sellers filed an action against a gas purchaser, alleging that the gas purchaser breached take or pay contracts and take and pay contracts by paying the escalated base price for deregulated gas instead of an redetermined price resulting from a gas shortage. The gas purchaser counterclaimed requesting a refund of payment made in excess of the escalated base price. The district court granted summary judgment to the gas purchaser. On appeal, the court held that there was sufficient evidence to raise a factual question regarding the gas purchaser's waiver of any right. I am not troubling your lordship. Kindly come to 3. The take or pay contract specifically provided for damages as a remedy upon breach of the contract. And 4, in the absence of a contracted remedy in the take or pay contract, the gas seller's remedy for breach was provided by the available seller's remedies under so and so judgment. The outcome was the court vacated the district court summary judgment, granting the purchaser counterclaim for a refund and remanded for the jury trial. Well, this was upset by the United States Court of Appeal. The United States Court of Appeal restored the judgment of the trial court. This your lordship will please to find. Kindly come to these interesting clauses. They have got this take or pay clause. Along with that, there is a clause, my lord. Kindly come to page 13. Page 13 of 16. And this is failure of buyer to take contract quantity. Your lordship has got that on left hand column top, page 13. The clause has been set out. If during any 1 year period, commencing with the first day of the month, in which initial delivery is made from each well, buyer shall fail to take the contract quantity of gas from such well, then the buyer shall pay the seller on or before the 20th day of the second month of the next following year for that quantity of gas, which is equal to the difference between the contract quantity and the buyer's actual takes during such period. During the 5 years next succeeding, this is important, succeeding a year in which the buyer has failed to take the gas so paid for, all gas taken by the buyer from seller, which is in excess of the contract quantity of gas for the current year, shall be known as make-up gas and shall be delivered without charge to the buyer until such excess equals to the amount of gas previously paid for but not taken, provided the buyer shall not be permitted to make up the cancelled allowance. Well, this is a mutuality. One is pay. This clause is not there in our contract. Take or pay. If you do not take or pay, if you do not take and pay, then for 5 years, for 5 years, if you take more, then the make-up clause will come into operation. So what the court held is that the parties had agreed as to how the damage is to be assessed. And on that basis, my lord, this judgment was delivered. And this your lordship will please to find head note 8 on the same page, head note 8. Furthermore, in so and so of the UCC specifically states the parties by agreement may provide for remedies in addition to or substitution for those provided in this article. Parties may provide remedies and may limit or alter the measure of damages recoverable under this article. We find that the language of 4.2 of the contract 422 and 516 unambiguously expresses the intent of penalty and CIG to fashion a specific remedy for breach by requiring CIG to pay the value of the shortfall, the contract price multiplied by the difference between the contract quantity and the amount of gas actually taken during 1 year period. And this is during the contractual period when there was a default. My lord, this amount was claimed in pursuance of this clause. It is really a specific performance of the clause in the contract during the subsistence of the contract. What happened was this, my lord, for 5 months or 6 months, my lord, this party did not take the quantum, the agreed quantum of gas. Then, my lord, the other party, the party in breach, did not pay. Then the party, my lord, which is not in breach, filed the proceedings for the purpose of recovery of this amount. At that point of time, the party in breach contended that, look, this is a penal clause. The court said, no, it is not a penal clause, and you are liable to pay this. So the amount of arrears which were not paid were directed to be paid in pursuance of this suit. My lord, this is really, my lord, upholding this take or pay clause. Upholding the clause by showing that there is a mutuality, parties have agreed to this. Therefore, my lord, I am submitting to your lordship, my lord, this is not really the issue which I am raising before your lordship in the facts of the instant case. So similarly is, my lord, the judgment of, this is a very well written judgment, I must say, my lord, the judgment of the Lahore High Court. Eta koto pata? Page 218. It's a longish judgment, my lord. I'm not going to trouble your lordship with that. The same thing, really what happened in this case was also the same thing, that the legality of take or pay clause. And my lord, here also the similar makeup clause was there in this case. And I find, my lord, in this judgment of Lahore High Court, this lady judge, Shahid Jamil Khan and Aisha A. Malik, judgment was delivered by Justice Malik, and she had considered very many judgments, including, my lord, the Indian judgments also, for the purpose of sustaining the take or pay clause. And there, my lord, only one thing I would like to show to your lordship. Kindly come to page, page তো এখানে আবার পাতা নেই, কোথায় আছে পাতাটি? Yes, page 31, paragraph 41. This paragraph I just placed before lordship from this judgment. Then again, I say that I'm not questioning the principles laid down in this, as I cannot question. And I am submitting that accepting these principles as correct principles, to what extent it can be made applicable in the case before your lordship. In the most recent case, in 2015 UKSC 67, the Supreme Court of the United Kingdom, your lordship has got this, discussed the issue of courts interfering in contracts freely entered into by parties and giving new meanings to the take or pay clause, which is common in commercial contracts, citing the case of Philips Hong Kong, etc., where it was observed that the court has to be careful not to set too stringent a standard, and was observed that the court and bear in mind that what the parties have agreed should normally be upheld, not least because any other approach will lead to undesirable uncertainty. The Supreme Court of the United Kingdom observed as follows. This is very important. There is a fundamental difference between a jurisdiction to review the fairness of a contractual obligation and a jurisdiction to regulate a remedy for its breach. I am emphasizing on this. Leaving aside the challenges going to the reality of consent, such as those based on fraud, duress, or undue influence, the courts do not review the fairness of men's bargain either at law or in equity. The penalty rule regulates only the remedies available for breach of a party's primary obligation, not the primary obligation themselves. The court observed in regard to what constitutes a penalty. This means that in some cases, the application of penalty rule may depend on how the relevant obligation is framed in the instrument. That is, whether as a conditional primary obligation or a secondary obligation providing contractual alternative to damages at law. Thus, where a contract contains an obligation on one party to perform an act and also provides that if he does not perform it, he will pay the other party a specified sum of money. The obligation to pay the specified sum of money is a secondary obligation which is capable of being a penalty. But if the contract does not impose expressly or impliedly an obligation to perform the act, but simply provides that if one party does not perform, he will pay the other party a specified sum. The obligation to pay the specified sum is a conditional primary obligation and cannot be a penalty. So, my lord, this is again the issue went into the question as to whether that this clause is a clause for liquidated damage or penalty. And that is clear from paragraph 44. The validity and enforceability of take or pay clause in contract is recognized in other common jurisdiction. And then, my lord, it says the rationale for take or pay minimum obligation is relatively routinely commercial. It means issues regarding quality and service do not override obligations to make payment if as much is clear from the contract terms. If a definite sum of money is required to engage the services of another, then that obligation must be met with the time frame required. Indeed, even if service has not been provided, if the contract anticipates that outcome, and even if the provider suffered no loss, if claims as to damage and mitigation of the loss are clearly excluded by the contract terms. The contract itself provided, so my lord, during the subsistence of the contract, the damage is provided there. So I don't have any reservation with regard to that. But then again, my lord, my submission is this, that if after the contract has come to an end, then what happens when you are, and this plaint is not on the basis of liquidated claim. The plaint is on claiming damage. Specific performance or damage. Specific performance not granted, damage has been granted. Up to 2034. I say, is it justified or not? Well, I have got only, these are the judgments which have been cited on this justifiability of the pay or take or pay clause. The only thing that is left, my lord, is I shall deal with the judgments which are dealing with, my lord, the damage. That is an important issue. Where, my lord, 15%, 20% has been granted. Brijpal Singh and other things.
Next Thursday.
Next Thursday. Not tomorrow. Benjamin.
Learned senior counsel appearing for the appellant, resumes his submission in reply, argument in reply, but does not conclude. Paragraph lists the matter once again. November 20, when this bench expects to assemble again.
Lordship will retain it by naturally, my lord.
It will be first matter, effectively. Time we can't tell you, either 3 or 3:30, that we can't tell you.
It will be at 2 o'clock or 3 o'clock.
Not 2, it's not possible, Mr. Mitra.
Not possible.
Either 3 or 3:30, because our respective determinations are very heavy determinations.
I know. We have seen.
Lordship, on a very urgent situation, Lordship, mentioning one matter to file a memorandum of appeal, Lordship, without certified copy.
When was the order passed?
Lordship, that 16th November, Lordship, 16th September.
16th November?
Yes, sir, Lordship, September. Lordship, that.
It's a regular bench.
Lordship, only that to file the memo, Lordship, without certificate.
Is this the regular bench?
Yes, Lordship.
It's a regular bench, no way.
Please explain to me.
Regular bench, no way.
Regular bench,